mentioned one matter for inclusion in the list. So this is a group
The
six.
inclusion you give next monthly list.
Application group 6 matter kindly inclusion in the list.
Lord, I am the respondent in this matter, my lord. I am traveling from Varanasi. This is consecutively third week, my lord. And my matter is listed, and appellants have just made the matter, taken the interim order, and not taking any steps for hearing, my lord. And I am suffering the
You
interim.
filed an application for vacating the interim order.
No, my lord.
You wait. Yes.
Item number 1.
I beg to appear for the petitioner. So this is that matter in which Lordship has referred the matter for mediation, my lord.
What is the outcome?
Lordship has been pleased to record, my lord, the outcome of the mediation in broad terms in your Lordship's order dated 17/11/2025.
Yes.
I appear on behalf of the respondent number 5.
Yes, how it is to be worked out? You tell us. What do you propose?
Lordship may direct the department to disburse the check separately as per their consent.
There has to be a pension payment order. Will have to be issued. You are appearing. Mr. Mukherjee,
Mr. Prasad is there. Mr. Prasad is there.
Yes.
you are for the state.
Yes.
How should it be worked out? They have agreed. It has come. It has come.
It is admissible because there are 4 gates under which it has been put there. At the time of dispersal, the data also to be collected, caption 60/40 ratio and taking their bank. It can be done.
Where is your bank details?
They giving the client is
We can record everything in the order, it will be fine. And if we record everything, then there will be no scope for anything after going back. That's why we are saying if you give the account numbers, it can be recorded.
Yes.
My lord may leave it blank, my lord. We will provide your lordship.
No, come with it. Not today, come tomorrow. For providing the learned state council
Item number 2.
For the respondent, your lordship, led by Mr. Shuddhodevada, he is not come, your lordship. Today is not well, your lordship. I'm praying for 1 week time, your lordship.
Let him 1 week, you want, as paid by the learned. Heading, or it can now, all right, let it come under the same heading.
My lord from HON'BLE, he is sick because he is infection in the throat.
No, we are saying it should come under the same heading or it should come in a different heading. It's coming under, it can be considered. Same heading.
Item number 3.
Your lordship, I am led by Advocate Shubhendu Bandyopadhyay, who is leading this matter on behalf of State LIC India. Currently, he is code number 24. Please grant me a short passover.
Lordship, we are for the respondent number 3.
Who is respondent number 3?
I appear from the behalf for the Notun. Well, I am for the writ petition respondent out here. Now there was a direction on the Oriental to be inducted as a party for which she is appearing, and I have preferred an application subject to the direction of the court. Since this is the application for addition of party out here, so the
Violation of?
party, addition of party. Why? If you kindly have a look at the trial court's order.
No, what is your application for?
This is a matter with regard to disbursal of terminal benefits to the deceased wife who was a petitioner hearing. Subsequently, when the trial court passed an order that one of the respondents, who is the mother-in-law,
What is the order passed by the trial?
trial court has decided that you should disburse the benefits to the person concerned in 1/3 ratio as per the Hindu Succession Act is concerned.
It has to be a portion between how many people? 3 people?
Three. Me, my son, and my mother-in-law.
You are?
And wife, Shoma, before the court. I
So
was
the-
the
the
initial applicant.
So the deceased mother, deceased wife and deceased son.
This is mother, this is mother, this is wife, this
And
is son.
deceased son, yes.
This is son. Since this is son, at that material point of time, was not a party to the proceeding, I was given a direction by my, on the erstwhile division bench to come up with the application. And I think the application is figuring in your lordship.
So without him being a party, it was a portion 1/3 each.
1/3 each. Because
In
in
his absence.
no, the difficulty was the person concerned, the wife concerned, initially came before the court with a prayer that my husband's retirement dues are not being disbursed. Subsequently, when it was challenged and subsequently the mother-in-law came in the scenario, court was of the view you distributed
So
with
during
1/3.
pendency of the writ petition, the employee passed away.
Prior to that, employee was, that is the reason why
So to begin with, it was a claim for family pension.
for all retirement dues, nothing was paid. Nothing was
Obviously,
paid. Nothing.
family pension and all other retirement.
Everything. Everything was
So he
kept.
died in harness.
Died in harness. Death was in harness, and since that is the reason why the trial court of the view that you distribute the money in 1/3 ratio. Be that as it may, what I'm on, since
What is, I'm trying to understand is the trial court directed 1/3 apportionment among 3 legal heirs without one of the legal heirs being a party to the writ proceeding.
without one of the yes and the legal participant. That is the difficulty. This 1/3 which belongs to the son is not being distributed. In fact, their own statement reveals that we are keeping it on hold.
So therefore, you want to be added as a
I
party.
want to be added as a party. I am also representing the
That is Can 1.
that is Can 1.
No
This-
order has been passed on Can 1.
Order has not yet been passed on Can 1.
So is there any dispute? regarding additional.
In fact, their statement, own statement is there. Lordship will find. If Lordship kindly turns up that.
No, no, is there a dispute by the,
I don't have any record information about this matter, Your Lordship.
He has, he's done.
what do you want?
I wanted Passover, Lordship. Oh,
Then let him be here. Let him be. No Passover, sir, then not today.
okay.
Not today.
Respondent number 3, I have filed my wakalatnama. We are
Give your appearance.
yes.
In fact, they were also to be added. Since the reason being, there was 50 lakhs which was ought to have been paid from their end. They are not paid.
When all the parties are here, we'll.
So today, everybody is here. I am also representing.
They are all represented, then we'll.
Because he is the one of the material respondents out here.
Therefore,
Let us come back to more. Let the matter retain its position.
it is nothing, just past, not today means it will be there.
It will be there. Great.
Item number 4.
Or I am for the petitioner, my lord. Earlier, I have filed supplementary affidavit as per leave granted by this court. The matter with regard to appointment under special compensation ground during the husband of the petitioner died during the period of COVID pandemic.
Why a supplementary was filed?
Supplementary filed as per leave of this court, my lord, because the what are the status in which status husband
OA
of the
was not annexed to the writ petition.
My lord,
The OA was not annexed to the writ petition.
earlier OA was not annexed to the writ.
There is a rejection order by the authorities.
By the rejection order by the authorities as well as by the.
Where is the rejection order by the authority?
Is the page at page 40. I don't know, at page 39 of the petition.
Yes.
From page 40, my lord. This is the circular dated 12/8/2000.
Page 41.
40.
Yes.
41 and thereafter 41. The application in which the appointment was applicable. The scheme will be applicable to a dependent family members of the following categories of employees who, while on COVID-19 related duty, have died or have been rendered permanently incapacitated due to the COVID-19 for further service. There is two categories. Number A, employees of state government, urban local bodies, public undertakings, statutory bodies, or any grant in aid institution. Under B, all frontline workers like ASHA workers, multi-purpose health workers, contractual workers, engaged under NHM, all contractual and part-time medical, paramedical, and nursing personnel, contractual workers employed in the health facilities, including drug management, cleaning, canning, and laundry, diet, and providing other services, Anganwadi workers and helpers, volunteers, civic police volunteers, such other contractual, casual, daily rated hired workers, volunteers in government establishment. My lord, husband of the petitioner falls under category A. Kindly come the impugned order, my lord. Kindly come impugned order. In view of the fact that the applicant's deceased husband was not a frontline worker during the COVID-19 period. COVID-19, I am frontline worker, I am not frontline worker, is it okay? But I am the permanent employee. The rule is not only restricted to the frontline workers, it is also applicable to the permanent employee also. This is my number one. And finally come to the memo of the office memo.
Yes.
With reference to the subject, page 39, with reference to the subject and memo noted above, I am directed to state that the late Mohan Chandra Noskar was a stenotypist and he was not treated as a COVID warrior's frontline workers, as his service was not being utilized to provide urgent medical treatment, etc. And now come to the etc. to the COVID affected population, which was the criteria to be COVID warrior in terms of the notification 2413 F-2 dated 12/8 of the urgent medical treatment and etc. And but in the circular it says the state government has galvanized the entire state machinery and mobilized all resources at its disposal to combat the situation arising due to outbreak of COVID-19. A large number of COVID warriors comprising permanent employees and contractual casual hired workers. Permanent employees and contractual casual hired workers, volunteers of the state government, urban and rural local bodies, public undertakings, and other statutory bodies under the state government are working day and night their life to provide urgent medical treatment and other support services. That was not disclosed in the rejection memo of the and other support services include all husband of the petitioner, in the memo, it was not stated who are the other support services, but in the circular, clearly stated the other support services.
So these are your two submissions.
My lord, I have an judgment of Odisha High Court. The 11th paragraph is page 9. Paragraph 6. Paragraph 6. From the above, it appeared that clearly there is also that 2021 at about 50 years. Starting was unwell being thus the petitioner was the case of the update of the petitioner satisfy the requirements of cost of the resolution of the annexure 7, and he was active line of duty dealing with service records of the staff and officers of the state office, which was controlling COVID management and was not only when he was diagnosed with COVID-19. He might not be starting in the field, but dealing with service records and related works of the state staff and officer and other related works of the COVID management. The said duty made him vulnerable to the COVID infection and ultimately end of the petitioner might not be a frontline workers, but he was engaged, he was entrusted duty in the office, dealing with he is also taking steno.
And the policy, where is the policy discussed?
Former constable in Odisha Police Service claims Asia
Not today, file it.
and special family benefit for the provision made in Finance Department. 4th August 2020, the petition. There are three certify that she does the certificate under exception clearly reveals that.
What is HRMS? What is HRMS?
Up to date version, all other HRMS.
Health related medical service.
This is HRMS service book and other HRMS maybe service and all other relating to
It may be anything.
maybe establishment.
It may be anything. You are relying on it, so you are obliged to tell us what is HRMS. It may be anything that we.
Human resource management services related work.
From where do we get this?
And consider the section of the.
So that is your sum.
Minor.
All right, got it. Don't invoke the sympathy. Sympathy is not going to get you anything. Either it applies or it does not apply. There is no question of sympathy. Based on sympathy, we cannot grant a relief.
My lord, I am trying to convince my lord we might not.
That those are not the issues. Is there any issue that you do not have children, therefore you are not getting any employment? That's not the issue. Where is the point in looking into these things? Yes.
Lordship, as I've already indicated, Your Lordship, the regulation which my learned friend is relying on and seeking appointment clearly indicates that the regulation will be applicable only to the frontline warriors who, during the service of in frontline management of the COVID, had been infected and succumbed to the COVID-19, Your Lordship. The 39, the order is also clear, Your Lordship. The department in no manner refuses her appointment. The only thing is, she is not entitled to appointment under the 2020 regulation, but she is entitled under the 251 EMP of 2013. Her candidature has to be considered under 251, Your Lordship. Page 40 is clear, Your Lordship, which says it is applicable to frontline warriors, Your Lordship. On the last occasion, I had indicated the definition, which indicates that frontline means in the most important or dangerous position, doing essential work that puts you at risk. And in the OA or in the writ petition, there is no submission saying that he was into frontline work. He was a stenographer who used to come to the office. We have recorded the attendance register also, Your Lordship. He had been throughout. Few days he had attended his office. Otherwise, he was on leave.
Yes.
And this judgment relied upon a single bench judgment of the Odisha High Court, which is otherwise factually also not applicable in this case.
But learned advocate.
appointment.
That's not the issue. So we have not expressed anything. You can pursue that matter. We are, nobody, that was not considered. There is no consideration on that aspect.
Item number 5.
Lordship, I am on behalf of the petitioner, Lordship. Copy has not been served upon us, Lordship,
Of
of the affidavit in opposition.
give him. Yes, how much time you want?
Lordship, I need 7 days time, Lordship, to file.
As prayed by petitioners. You don't want to file anything. No, their stand is not to your detriment. Their stand.
Item number 6.
My lord, I am seeking 1 week adjournment for filing reply, my lord. Last Friday, my lord, they have served opposition.
As paid by petitioners council.
Item number 7 and 8.
Only not the matter. Counting is going on. It is expected to be over by.
Good luck to him.
Yes, not good. Yes.
Item number 9.
Mr. Tapan Kumar Mukherjee, Lordship, in the last occasion, there is a direction to file opposition. Lordship, I'm praying for 2 weeks' time, Lordship.
None appears for your.
Item number 11.
Lordship, in item number 11, I appear on behalf of the petitioner. Lordship, on last occasion, there was a direction upon the state respondent to file and counter affidavit. Lordship, we have not received the counter affidavit.
Lordship, I'm late by Mr. Tapan Kumar Mukherjee, Lordship, I'm praying for 2 weeks extension, Lordship.
Every case you need one extension. Same on. Instead of none appears, take it.
Item number 12.
on appears on paper.
Item number 13.
I am put a petitioner led by Mr. Vidyosamy. He is on his leg. Kindly make it not this week.
As prayed, matter is adjourned for. Which
Item number 15.
Well, item 15
is going on with which association?
Well, it's a bar life. But there is a series of matter, my lord, those matters relates to, my lord, resignation of doctors. Now, my lord, there is a rejection order stating the same plea, the death of doctors, which has been already decided by your lordship long back. Now, my lord, they have asked, they have said, my lord, thereafter, my lord, opposition was filed. Well, we filed our reply there too. In the opposition, my lord, practically they have taken the same stand they have taken in the rejection order. The rejection order is, my lord, at page
Wherein
15, my lord. The London government release here, my lord.
proceed.
Page 90 is a rejection order, which is impugned, I must say, my lord. The
It is one of those matters where resignation of doctors is being withheld by the government. Your lordship has delivered at least, I have come across at least 3 sitting with Justice Tandon, then were your lordship's own orders. So, my lord, consistently, my lord, this is the stand of the government that because of lack of academic staff and for patient care, it is not possible to allow them to resign at this juncture. Now, my lord, there are some developments in the meanwhile. My lord, due to pendency of the matter relating to OBC candidates, the recruitment process was held up. Now, my lord, the recruitment process has my lord, of new doctors has taken place. This is something new which was not there earlier. I was not aware of it. I came to know only yesterday. Now, my lord, I have got written instructions, my lord, that my lord, West Bengal Health Recruitment Board has issued notifications inviting applications for recruitment to various categories of posts and vacancy against 527 declared vacancies of doctors. If once they are recruited, my lord, they may be possibly they will have no difficulty in getting their resignations accepted by the authorities. Now, my lord, this is number one. And my lord, the interviews for various posts are going on for the recruitment process. And my lord, it will be completed by the end of December 19, 2025. That's what I have said. So, my lord, I have got the written instruction. This is not in the form of affidavit. If your lordship want, my lord, if some breathing space, if and my lord, I find, my lord, that in your one of your lordship's order, presided by your lordship Justice Prasad, my lord, there, my your lordship, an exception was carved out that if there is prejudice or disciplinary proceeding or criminal proceeding pending or lack of vigilance clearance, etc., this can be held up. I take advantage of that one exception that has been carved out by your lordship. So, my lord, if since the recruitment process is on, and my lord, I am told, my lord, the interviews will be completed by the end of December 2025. If sometime, my lord, if on this ground, my lord, if the matter is deferred, then, my lord, the academic interest and the patient care will not be in jeopardy. So, my lord, if I put it on record, my lord, this is the instruction, I cannot, this is the advocate's instruction, this is my privilege, I can't put on record. Only on that ground. But the lordship's view is very clear that there is no, the rule has been tested even before the Supreme Court. Lordship's order is there. Even before it was tested before the Honorable Supreme Court. So, my lordship's view has been upheld. That is no rule.
That order was challenged before the Supreme Court also.
In your lordship's order, it is there.
But one matter was challenged, my lord, that was delivered by my lord Justice Nishita Matre and my lord Justice Taposh Mukherjee as the
Anyway,
lordship.
but on the same issue.
But on the same issue.
Same issue. That's what I am.
There are other judgments also.
Your lordship's judgments are very clear. It cannot do with it. The rule has been has not been struck down. The rule is operative. Your lordship's consistent view. But I
Yes, what is your stand?
That's it. My stand is, my lord, your lordship kindly take note. Your lordship has categorically mentioned in your lordship's order, taking note of the earlier judgments of this honorable.
That's not the point. The point is only why we ask you. Because if they say that by the end of this month, this procedure is to be completed, then you want to make it an issue, we can proceed.
Only thing subject lordship kindly with this, my lord. As because, my lord, we have tendered resignation, my lord. Thereafter, my lord, this order comes out. This order comes out with a.
We are not on the legalities. We can go into that. There is no problem. Please don't in the least think that we are trying to skirt the issue. We will go through it if required. What we are saying is you have served for at least 10 years or 20 years.
Most of the doctors.
Maybe more. They are saying it is a precarious situation, healthcare service. That is legally, whether that is acceptable or not, we have already decided. So that is not the issue.
Absolutely,
so if they say that by end of this month it is expected, it will be over. Should we wait till January or should we proceed?
Only predicament
is there, because if there is some employment already you have applied, something like that, which can't wait.
My your lordship has more experience. My lordship will recall, my lord, just to get an NOC, I have to approach this on.
We have seen that.
So now the predicament that we are facing is this. But even if this offer letter is there, my lord, they will ask for the NOC. But they will never give the NOC. Again, a second lot of litigation will be
taken. So therefore, it may be in your interest. That is why we are saying, what is your stand? If it can come in January first week, we can list it at 2 p.m. If the thing doesn't go through, we can decide it. If in the meantime they are able to avail your services for the public interest, this would only be based on your stand.
My lord,
you can.
So, my lord, lordship grants me. The client is the best person to tell what his stance is. I cannot.
Obviously, we understand. We understand what you are saying. So just take a stand. Otherwise, he is also aware what will be the fate of the case. You are also aware what will be the fate of the case. He has come forward with a very, we don't know what to say, maybe not legally acceptable, but something which may be considered by you because you have served for so long. If you don't want to consider, if there is something which can't wait,
Yes, ma'am.
we will not, we will appreciate what you are saying. But
As your lordship, let me take instruction, my lord, as well. They are the, I'm on behalf of the, I'm standing, my lord. Let me talk to them, my lord.
correct,
Whatever
you
instruction
have
comes,
to,
we
you have.
My lord, should I put it on record, my lord, by your report in the form of affidavit that this, I want to, my lord.
It's your instruction, you have written instructions.
I have written.
Yes. So we are not recording any order.
Let that be on Monday, my lord. Tomorrow I have some
As
difficulty.
jointly prayed, list on Monday.
On 8th. Can it be on Tuesday, my lord, instead of 8th, it is 9th.
Let it come, let's see what is their stand. Let us see what is their stand. They may not be in a position to accept, we don't know, or they may be. Let them see.
Well, there are series of matters are there.
There are 18, but I am also in 18, same order may be passed in 18 also.
My lord, am I allowed?
18, 18, yes, sir.
Yes, sir, yes, sir.
You are in 18 also.
15, 16, 17, 18, 20, 22. Well, these are all identical matters.
Can you
And
ask your assisting counsel to give it on a slip of paper
Sure.
so that there is no confusion?
Yes.
I am in 15 and 18.
All right, you give your appearance,
No, lordship, lordship.
take slip, give a slip so that in all the cases, same order can be passed.
16, 17,
I'm grateful. Lord.
17,
18.
18.
2022.
If the due recruitment takes place, well, then everything will be sorted out.
2022 of this.
Let's see what they have to say.
24.
527 posts.
We will see what they have to say. We are not very much swayed by the argument, but let's see.
My lord, only thing, my lord, as because and now the matter is over, my lord. Your lordship has found, my lord, even getting an NOC is a Herculean task in this case, my lord.
We have gone through, therefore we asked.
I understand, my lord.
19 বাদে
Lordship, grateful.
21 আর 23 বাদে
My lord, with regard to item number 17 of this lot, I'm led by Mr. Shen. In this matter, the resignation has been accepted. In 17, my lord, I sincerely apologize, my lord. I have one copy. Navnita Bhadra. Dasgupta.
That means আমাকে একটা কপি দেবেন
আমি
আমার হয়ে গেছে ঝামেলা চুকে গেছে
Dr. Nabanita Dasgupta.
Item number 17.
17.
Associate Professor Department, Jhargram Government Medical College.
She is associate professor, Jhargram Government Medical College and
You
Hospital.
have been served a copy.
No, my lord.
No, my lord, I shall.
Sir, I will get it from my.
No, just have a look. Just tally the name and posting and all, everything, go through it.
Accept resignation, subject to obtaining her integrity clearance issued by the State Vigilance Commission, West Bengal, and also the same for the Vigilance necessary action after clearance. Yellow. Associate Professor Ibarmundi G and O.
So give us 3 copies.
My lord, I shall.
One for him.
I shall kindly allows me 10 minutes. I shall.
What I get, my lord, they are saying, my lord, the vigilance clearance is required. My lord, let that be time bound. My lord, or else it will be also in eternity. My lord, the things which is happening now, my lord, to be very candid, my lord, it's not the way it should be functioning.
So within 4 weeks, they will take.
My lord, in all probability, my lord, this is just a statement, my lord. I'm not sure about it. She has joined somewhere else, so everything has been completed. In all probability, my lord,
Still will give you 4 weeks.
my lord,
We are in.
my lord, I shall make a copy.
Only for 7.
A report I shall.
Please, yes, give it. The written instruction dated, what is the date of that instruction?
It's 6th of November, 2025.
25 is taken on record.
Or November.
You can get a copy, just photocopy. Yeah.
Item number 19.
But in this matter, my lord, I appear for the petitioner, my lord. On the last occasion, my lord, my other side took time from your lordship to file an affidavit. We have not yet received.
And today he has vanished.
Before vacation also, my lord, they took time for filing affidavit. But the matter pertains to, my lord, studied leave.
So ask him to come. We are just adjourning it for the day. Maybe he has a opposition is prepared. We don't know. If he's there tomorrow, we can see whether it is to be handed over or some time is to be not to.
I'm grateful.
Twenty-one.
Your Lordship, I am appearing for the petition on behalf of my learned senior. He is in the Central Administrative. I am praying for short passover, Your Lordship. He is not.
Twenty-three.
Completed our petitioner. You are the petitioner.
I am appearing on.
You are for the respondent.
For the respondent.
Sole respondent.
Sole respondent. My lord. The matter where, my lord, the BHMS, the petitioner had completed their degree and he was successful. Now, my lord, the tribunal has held that on the basis of the resolution by which it was done, it was after the date of publication of the advertisement and other things. Now, my lord, the contention is this, that, my lord, for the very first time, the state has come up with a point before this court. He is possessing a graded BHMS and he is not possessing the BHMS.
Let's say one thing, Lord, he's reopening his case again. 3 days, your lordship has heard. Consecutive days.
Why it was kept today?
Yes, your lordship has asked a very pertinent question. He has
my lord.
he has taken instruction his client inside the court,
me-
and your lordship has said, we are adjourning the matter, kindly take instruction in chamber. Everything has been done.
Let me make my submission.
Then he is reopening case, Lord, 3 days after.
Let me make my submission, sir.
What submission? You have already made your submission.
No, I have not made my submission on this point.
Already made your submission.
Yes, we have heard you.
No, my lord, I have got one point to, my lord, one point to, my lord, argue before you.
May I argue the point which you have not argued?
Yes, that I have not argued, my lord.
Yes.
But this is the point is this, my lord, that the point of they are taking that I do not possess the graded BHMS. Now, my lord, this point was never taken by them before the learned tribunal. This is being taken for the very first time, my lord, before this court only. While they are coming up challenging the impugning order.
All right.
Now, my lord, this is the point. Now, my lord, I say this, the Tej Prakash Pathok, my lord, it clearly states that the rules of the game, my lord, cannot be changed.
Now you are arguing what you have argued.
No, my lord,
now you are arguing what you have
no,
argued.
my lord, I'm just simply stating this.
Don't state that,
my lord.
We asked you to say what you have not said.
Now, my
You
lord,
have already said.
Now, my lord, I say this point of graded BHMS, which they are taking now, my lord, ought to have been taken by them before the learned tribunal while the case had come up for the very first time.
Yes.
Now, my lord, therefore, my lord, my humble submission is this, that this point of graded BHMS cannot be taken by them for the very first time here, which they had never ever argued or urged their point before the tribunal. Now, my lord, therefore, they are stopped and barred to take such point.
Please. Application heading. এখানে contempt আছে তাহলে এক বছর সাইকেল তলায় তো হ্যাঁ সবাতে
What is the date of the reasoned order?
Annexure P7, dated 23rd November 2023. 23rd November 2020.
At which page?
Page 31. There's 31. And last column is start বলছে start 31. 8 and 11, right? Oh, hi.
Where is the RTI reply? At which page? RTI reply?
Page 27.
Yes. That's the order. Now, sorry, sir. But on that date, my learned junior, but has been able to, subject to correction, able to satisfy the court regarding the calculation of marks. 69.5, and my learned friend's client is harping on the 80, 79.5.
He says he should have got 80.5
My lord,
instead of
that's why my
75.
lord has asked him to satisfy the court.
Yes.
And thereafter he wants to take instructions inside the court, then your lordship has adjourned.
Yes.
Not certain instruction from he suddenly jumped up, my lord.
Now we are reminded of what happened. You did not ask him, he just jumped up and he started coming. We were not appreciating that
Yes, my lord,
conduct.
even I apologize, my lord. That day
So
I
now, where is that marks? From where did you should assert the marks? That is the only issue.
But the RTI reply itself shows that I got academic 69.5, interview mark 6, and experience 5. Now, my lord, if these are added, it will definitely come to.
Yes, we were looking at the RTI reply that day.
Yes, my lord.
69.5 you have got for academic score.
Yes, my lord. And experience is 5 and interview is 6.
Interview is 6, yes.
And experience is 5. Now, my lord, if all these are added up, I say, my lord, it comes to 80.5. But my lord, in the reasoned order, they are saying, and in their stand before the tribunal, they have stated that 69.5 is inclusive of your experience marks. Now, my lord, I say this cannot be, because there was a separate column also in the advertisement notification itself, which had stated that for interview separate, for experience separate marks is to be given. Now, my lord, some marks must be there for experience, and that is, my lord, 5 marks, which is apparent there from their reply itself. Therefore, my lord, if all these threes are added up, the 3 marks, I come to 80.05.
So according to them, 69.5 plus 5 is the academic score.
Yes, my lord.
Not academic score, some other term they have used.
They have stated, my lord, including experience.
No, they have used some other term. All right. That's all. Yes. All right.
Item number 25.
25 is my application, my lord. Your lordship may recall, your lordship heard me on Thursday.
Hmm?
My lord, whether the charge sheet can be challenged or not, this was the issue, my lord. Your lordship may heard me on last Thursday. My lord, I've gone through the judgments, my lord. My lord, it was known to me, but still I've gone through the judgment. What I get, my lord, the charge sheet or the show cause could not be normally challenged unless it is issued by incompetent authority or the charge itself doesn't say any charge. Or the third option, my lord, there is given, my lord, if any extra circumstantial things is there, then only the charge sheet can be interfered with. Now, my lord, in this case, what has happened, my lord, the charge sheet which is there was issued by the competent authority, the memoranda. But the annexures where the charges have been framed, that has been done by the State Vigilance Commission with a dictation. Well, my contention is an act of dictation by the State Vigilance Commission while framing of the charges. Well, this is my contention. Now, my lord, what I get is this. My lord, it's not in dispute. This cannot be challenged. My lord, your lordship has already said. I have also checked. My lord, there's nothing I can find, my lord, that says contrary what your lordship has said. The only thing is this, my lord, the annexures which have been issued, that was issued by a deputy secretary. He is not competent. The memorandum may be of a competent authority. My lord, let that be taken into consideration. Let fresh charge be issued. At least, I'm not saying the memorandum. My lord, charges be issued, my lord, as because that has been issued by the deputy secretary of vigilance, who is no one with regard to my disciplinary authority is concerned.
So we have understood what you are saying is since incompetence is a ground, the charge memo contains allegations which have been forwarded by an authority who is incompetent. Now, what if the charge memo contains an annexure of a private individual making a complaint against you?
No, my lord, the vigilance rules, that is 2012 rules.
No, what we are saying is a private individual by no stretch of imagination he will have any role to play in issuance of charge memo.
Absolutely.
Now he gives an allegation, 3-point allegation, and that forms part of the charge memo. So will that invalidate the charge memo because it contains an annexure issued by an incompetent authority?
That should not be. That is the basis of the charge. I may not be saying, my lord.
So the vigilance, whatever it has forwarded is the basis of the charge. The charge has been issued by the disciplinary authority. He has applied his mind. We don't know at this stage whether the court is to interfere in such a matter.
But with regard to, my lord, this punishment part is concerned, what your lordship has said, I got many judgments which says nobody can be directed by the to direct the authorities to pass certain punishment. That is
Cannot
there.
be. That is beyond our scope.
Yes, but that is there. But
Only if it is shocking to the conscience, if it is highly excessive in certain circumstances, at best, in a rare case, we can direct for reconsideration. We cannot substitute our opinion.
no, absolutely not. My lord. That is what your lordship has said. I want that.
This is the law.
The only thing that I'm saying, my lord, sub lordship, I may.
Let us see the charge memo.
Yes, my lord. My lord, the charge memo is at page 34. It is issued by the competent authority. I may not be saying, my lord. What is there?
And which is the annexure?
My lord, it starts from page, my lord, 37. My lord, it also says that page 37 page says, my lord,
Your opposition is ready. Let him file.
But I will be getting breathing space, but I will never object to it.
For filing opposition, 2 weeks time is allowed. List after 3 weeks, if the
Item number 26. Vice versa.
yes, take down. None appears on behalf.
Vice versa. 27.
Respondent.
Learned, my lord, learned advocate Binoy Mishra not come to court, not this week.
Huh?
Learned advocate Binoy Mishra not come to court, not this week.
As prayed by learned advocate for after that. It will come on 15th.
But 28.
Applicant.
না বার করে দিল
28 malad is a contempt application. And malad the respondent also filed one review application, madam. Malad let the review application may be listed for here.
This is arising out of?
Yes.
Arising out of Central Administrative Tribunal.
Yes.
Order passed by a bench of which one of us was member.
No, malad by this Honorable High Court passed this order. Not your lordship bench and earlier determination.
Final order is of which date? Oh. 25/1/23. Final order is 25/1/23.
Malad that order was passed on 25th of January 2023.
25/1/23. That is what we are saying. Yes. And what is the review number?
Malad review number is 216 of 2023.
3.
216 of 2023.
Here also please say that
That we have to complete that.
That review is not assigned to this bench.
Yes, sir.
That review, whether it is also assigned to this bench.
Well, reviews.
We understand what you are saying, but there is no assignment. So should we direct for placing it here? That is what we are trying to understand. Should we direct for placing it here, or it should come through the Honorable the Chief Justice?
It has to be assigned.
Has to be assigned. Has to be assigned. We are informed by
ডিপার্টমেন্টে পাঠাবো চলে এগুলো এখানে হয় না ডিপার্টমেন্ট হ্যাঁ এখানে হয় না
Item number 29.
Please, Your Lordships. This is my contempt application, my lord. And then my learned friends on the last occasion had filed an affidavit indicating, my lord, that they filed a review petition which is pending before the Supreme Court. I'll briefly tell your Lordship, my lord, a few relevant facts, my lord, or dates. So it's a matter, my lord, which was filed by me initially before the West Bengal Land Reform Tribunal, seeking mutation of my name as the owner of the property. I lost. I came up before this court. I succeeded. Then they went up before the Supreme Court. They lost in their SLP. They lost, my lord, on 22nd July 2024. Then, my lord, they filed a review petition on 17th of May 2025. So sufficient amount, about a delay of, my lord, 269 days.
When?
They filed it, my lord, on 17th May 2025. So there was a delay of about 269 days.
Yes.
My contempt application was filed before they filed their review on 7th May. Their only defense, my lord, is that a review application is pending before the Supreme Court. Now, my lord, it's been more than 6.5 months since the review application was filed. They have not managed to get any order of stay. I do not know what they are doing with the review application, whether they are taking any steps, whether they are pursuing it or not. Today, my lord, there is no impediment for your lordships, my lord, to take up and consider this contempt application and take, my lord, pass necessary orders. Today, my lord, I'm praying that a rule be issued, my lord, on the alleged contemners. I must also, out of fairness, my lord, indicate to your lordships, my lord, that we had also filed a special leave petition, my lord, from one of the orders passed in this contempt application. And the Honorable Supreme Court, my lord, has directed, my lord, we do not have a copy of the order, but the advocate on record out there has indicated that there's been a direction, my lord, to dispose of this matter within a period of 3 months, since there is no stay.
Where is that order?
That order I do not have, my lord. I have a letter, my lord. That order is not yet available online, but I have a letter, my lord. Dada,
On 24th.
My lord, even if this order is not there, my lord, I am humbly submitting, my lord. I have every right to proceed with my contempt application today. There is no impediment. The judgment is binding, conclusive. Matter has traveled all the way up to the Supreme Court.
And what affidavit they have filed?
They have filed, my lord, an affidavit bringing on record, my lord, the review petition filed by them.
That's all.
That's it. So, my lord had been given me leave, my lord, to file an exception. I don't need to file an exception.
I am not denying any submission of my learned senior friend, my lord. Kindly, my lord, one opportunity, my lord, will take steps, my lord, after 2 weeks or 3 weeks times, my lord. Either my lord will pass this order, my lord, after 3 weeks, my lord. My lord, this is the last chance, my lord. If there are not any order of this, if we issue a
Are you in touch with the authority? Are you in touch with the authority?
Yes, my lord, today, my lord, I call this authority, my lord. My lord, they also, my lord, inform this advocate on record of this affix code, my lord. And my lord, this is, my lord, we are trying to listing this matter before this affix court, my lord. My lord, kindly,
There's no
my lord,
question of listing.
my lord, I understand, my lord, this is the learned friend and my lords, kindly, my lord, one accommodation, it is the last opportunity. If we are not get any order, my lord, will take steps, my lord, according to my lord.
There is no question of such opportunity being granted to you. Where is the order? Can you give us a copy of the order?
The order passed by the Supreme Court?
Yes.
It's not yet been uploaded, which is why I do not have it, my lord. Which is written also in that letter. It's not yet been uploaded. We have applied for a certified copy as
No,
well.
but this is of 26th.
November.
Today is 1st.
I know, but for whatever reason, it's not been uploaded, my lord.
You have checked today?
Yes, yes. We checked today only. I just checked 10 minutes ago while sitting outside waiting for this matter.
I also checked out, my lord.
No, we'd like to incorporate the order, therefore we are
I appreciate that.
we are adjourning it for the day. Let's see whether it is available by tomorrow or not.
And my humble submission will be, even if this order is not there, my lord, they have no really defense.
Correct. But then let us see what is the situation. Not
Well, could it be kept after 1 week? I think within this week, hopefully the order will be uploaded rather than us coming back repeatedly and troubling your
to
lordship.
be listed after a week.
Appearance to the
Yes.
Item number 30.
This matter, there is a change of panel. The new bank has amalgamated the earlier advocate who is filing this appeal is not in the panel now. I am instructed to appear. The issue involved in this application are already before the before Supreme Court.
What is this?
I am for the writ petitioner, but no copy of the memo, no copy of the stay.
I also don't have for the copy, my lord.
Nothing has been served upon us.
Apply for the certified copy.
What my learned friend is suggesting the issue is pending before the Honorable Supreme Court. I have no idea about the same also.
This arises out of which order? This arises out of which order?
My lord, the order passed by the Justice identical order, my lord. And it is instructed from the bank, my lord. The earlier who is appearing for the advocate on record, he is not in the panel now. We have to apply for the certified copy of the law. Let me apply for the certified copy, my lord, and apply for it. I take the copy. আমাদের পরে এটা তো দিতে পারছি, এটা তো চ্যালেঞ্জ, এটা সেই
So you're for the bank.
fine, for the bank, newly engaged.
At least give him a copy if he's.
Well, I have to take it from the department by.
So you take it and give it to him. Earlier, which council was appearing? What was his name?
On the Bhattacharya.
You have filed a fresh Vakalatnama.
So by today, my lord, I filed. Just instructed me to authorize and they give it.
You give your whoever is going to file the Vakalatnama, you please give his name.
I am filing it.
Yes, Mr. So and so.
Bank is, I get Vakalatnama and engagement from the bank, but copy is not in the bank.
Yeah. Last.
আমার নাম্বারটা দিয়ে যাবে, ঠিক আছে? এ দিয়ে যে নাম্বারটা 23rd December. পাঠিয়ে দেবো।
File the Vakalatnama in the department. No, we have said you will file it during the course of the day.
Item number 31.
For the appellant, last occasion, this matter was adjourned for getting some precedent over the issue. That somebody has been appointed subsequently, though I have challenged the panel where I was placed as successful, but during pendency of the writ petition, some fresh advertisement has been made and somebody has been given appointment for the post of Asha. Your lordship's query was whether that advertisement was challenged or brought to the notice of this honorable court or not, whether interim order was sought for or not. For that reason, one can was filed in 2020 challenging the said advertisement, and that can was disposed of on 27th 9 without granting interim order. His lordship was pleased to direct the authority to file a report and to decide the issue on merit. Therefore, that can is required. My lord, what was my prayer?
Can is disposed of. Why it is
My
required?
lord, because whether
Order is still here.
true, whether I have challenged that selection.
But since no order has been passed, you may have made a bundle of prayers. How is it of any consequence today? If not granted, you had the opportunity, you have taken no steps. So we'll go by the order passed on the can. Contents of the can today does not make any difference.
My lord, only thing, my lord, the precedent for some judgments, my lord, I will be seeking for 1 week time.
Piecemeal reply you are giving.
No, because can is also required.
Required, not at all. It hardly matters what is stated in the can once the order has been passed. If an order has been passed disposing of the can, whatever relief you had prayed is today of no consequence because not granted by the court. Therefore, you may have made many prayers, but you have not taken steps. You will come back to the same position.
Your lordship's query was whether after the filing of this writ petition, subsequent selection process, whether that was brought to the notice of the court or not. That was.
That's not an issue now. Only issue is in the circumstances which has already crystallized whether any relief can be granted to you. That is why the Honorable Single Judge has found at best what could be done is to identify the person who is responsible. They have not challenged that direction. What relief can flow to you? Nothing.
May I come back after a week? Because the court
Tomorrow, come with any precedent you want tomorrow, not today.
Anything, next week, anything.
No, sir. We have dictated this order last day that you have to come with precedent. You have not come with precedent today. So we are giving you today. That is enough. This can't be done on every day.
Taken off. That's great. If
32.
We have the respondent appellant back, my lord. Challenging the order of the single bench, my lord. The single bench, my lord, set aside the order passed by the appellate authority. So the impugned order is page 233 onwards.
33.
233. Volume 2.
Yes.
Well, another against
You are
this
appearing for the respondent.
against this, my lord, the officer of the bank, my lord, the charge sheet issued on, my lord, 13 May 2011. Charge sheet issued. There is a financial loss more than, my lord, 1 crore 50 lakhs. And, my lord, after the issuance of charge sheet, my lord, the disciplinary proceeding started, my lord. And he filed the reply to the charge sheet, my lord, on 16th June, my lord. Thereafter, my lord, department inquiry started from 24th of June 2011. Subsequently, my lord, after the order passed by the, my lord, the disciplinary authority initially, my lord, this petitioner filed a writ application and subsequently, my lord, an appeal preferred. The authority, this court, my lord, directed that the charge sheet remain the same. Let they issue a fresh inquiry. Again, my lord, the inquiry was after, but the charge sheet there, my lord, it is remain untouched. The charge sheet issued by the appropriate authority, my lord, as per the regulation, as per the rules. And the order passed by the appellate authority, my lord, the second order passed by appellate authority on 2015, my lord, he again preferred an appeal. And 2019, my lord, the appellate authority again confirmed the order of the disciplinary authority on, my lord, 17/4/2019. Thereafter, he filed this, my lord, writ application, and against, my lord, we have come before your lordship.
The disciplinary authority's order is of 23/9/15.
Last order, my lord, 17/4/2019, appellate authority. And the order passed by the disciplinary authority last, my lord, 23/9/2015, page 203 to 210.
Page?
203 to 210, my lord.
And appellate authority's order?
My lord, appellate authority order, my lord, 226 onwards, my lord.
What is the date?
Date, my lord, 17th April 2019.
Which page?
Page, my lord, 226 onwards.
Yes. So today it is only these two orders which are relevant.
Yes, my lord. Now these orders are relevant, my lord. And the charge sheet, the same charge sheet, upon the same.
Obviously.
Yes.
That is not in dispute. There is no dispute on this aspect.
Right. And main grievance, my lord, our grievance is that of the bank, my lord, the charge sheet is quashed by the single bench. And, my lord, as he is retired from the service, everything is, my lord, as per the regulation 45, because regulation 45 of the bank says that if, my lord, after retirement, disciplinary proceeding can be initiated. And the court dismissed on the ground, my lord, rejected the quash the charge sheet, and the ground taken that he is already retired, so no new thing will be involved. Well, there is no breach of national justice, my lord. Every, my lord, steps has been taken properly, my lord, and the charge sheet there is which is quashed, my lord. It is already another division bench already, my lord, it tested by the another division bench. There it is also there. And, my lord, there is a regulation, my lord, 45.
What is his date of retirement? Sometime in 2015. 14. The rule regarding proceeding against a retired officer has been considered in this judgment.
No, my lord. There is a regulation 45 is there, my lord.
What does it say? It can continue even after retirement.
Yes, page. I'm just. Yeah, I'm giving the page. It is from in regulation, my lord, annex in page 55 onwards. I am giving appropriate, my lord, page. Page 74, volume 1. Disciplinary proceeding after retirement. Because, my lord, the disciplinary proceeding already initiated is going after his return.
Yes.
And my lord, one of the coordinate bench also, my lord, same identical types of issues, my lord, where he retired. But, my lord, the disciplinary proceeding initiated after retirement by the order of this court. My learned friend is also respondent there.
Where is the order passed in the AST? Earlier AST.
190. And extra P29.
So this order has been passed much after you retired. The order in the earlier AST.
For retirement is concerned, my lord, rule says it can be continued.
So therefore, that is his only grievance.
This grievance is the order of the learned signature, where the entire thing has been quashed and set aside.
What does that mean? When it is entirely quashed, how they will proceed?
The learned signature proceeded on the basis of the division bench order. Division bench.
That is what we are saying. The division bench directed to reconsider with reference to the material on record. Your grievance is again he has reproduced the same order without considering the records. To that extent, even if it is inferred that for the moment that yes, actually they have repeated without referring to the records, can this order be passed? That since it is so long since he has retired, therefore it is.
Judgments. 11 years, it is not possible to reinitiate the proceedings.
It's not a case of initiate. See, it is in amounts to reviewing the order passed in AST 188 of 2014.
No answer and directed consider the matter on the basis of the inquiry report and give reasons. I shall show your lordship the order which has been passed in the earlier proceedings and the present one. It says nothing but the cyclostyle work. In both.
It's not. Have we asked you about that? We are not asking you on that issue.
First part is that only the order of discrepancy goes and the order of the appeal authority goes. Only remains for the charge. The question is, my lord, whether the fresh posting can be continued after 11 years. Supreme Court of platinum of judgment says at this stage it is not permissible to allow authority concern level because this is their fault. Twice they have faulted. Can you take note of? And the another part of the order is that the order has been given retrospective effect. I shall note the Supreme Court judgment also. Kindly see the order of the disputed authority. Just for a moment.
No, that even if he has given a retrospective, the only issue he is raising is that charge sheet has been quashed.
If the charge is revived, then whether they will be allowed to continue. So for that part is concerned, I understood because division bench has not the charge sheet. Rather was the order of the disciplinary authority and the appellate authority directly.
So what you are saying is after 2015,
yes,
8 years more have passed, and therefore the judge has taken note of that.
Absolutely, man. This is my case. That at this stage, after 14 years, 14 years, it cannot be possible by now. Because this, one of the facts is that in the charge sheet, they have disclosed the name of two inquiry officers.
All right, we'll fix it for hearing.
Pay scale is up.
It's the issue of a law. Let us see. Whenever. When?
I have not even calculated. Any. Next week, any.
Next week. Next week will not be possible. You need not cite multiple judgments on the same point.
No, I have brought on two judgments. But there is no settled principle, my lord, that at this stage whether court will permit or not. Because witnesses, no more they are. The persons concerned who has given evidence, they are no more there. That's the basic principle, my lord, as I understood. After 11 years.
What is the leading judgment? No, this is not a case of dispute.
No. But Mr. Mukherjee also considered this for part of the whether in that stage it will be allowed or not.
No, where is that judgment? Therefore, we are asking, we are not telling you.
Your apex one judgment which says after retirement, there should not be any order of punishment to the effect of termination or like that. Only pensionary benefit can be attached. According to my understanding, this is to some extent my service effective, so far the benefit is curtailed. It cannot be done.
They have reverted you only.
This cannot go. That was the judgment. It says, my lord, only pensionary benefits. Reversion is pay scale is not permissible.
That will also depend on the rules. What is the scope of the rules?
Rule has not been identified anything. Only they can continue. If
only they can continue.
Rules says if it starts prior to retirement, it can be continued.
No,
that's all it is.
You have a point there worth considering whether once he has attained the superannuation, where is the question of anything else other than making recovery from the retired.
That's not going to happen.
And the other aspect is that judgment you have not come with on delay.
But Bank and another person, Rajiv Dal, possibly your lordship has 2007, or the one paragraph is suffice.
No, and on delay also there is a judgment. The apex court has held.
No, delay, there are judgments. There are judgments. Almost all the judgments says after 10 to 11 years, it's not possible.
Yes, the apex court has taken note that human memory is short. The witnesses may not.
This part has also.
The witnesses may not be available. The records are
treated as well as departmental witness.
The delinquent can't be expected to remember it.
And yes, there is a latest judgment of 2024 also from that score also. Nihal Singh.
All right, we'll consider. So this is the scope of hearing.
It's only one. If the landed senior possibly while proceeded at the time of quashing the charge sheet, that whether survival of the proceedings is permissible or not. But there was no such consideration in the.
So according to you, both the issues are still open. The first issue regarding whether such a punishment can be inflicted post-retirement, even if the service rule permits that the proceeding will continue.
Retirement.
At best, it can be for recovery from the dues. If there can be no dismissal or termination after retirement.
That cannot dismiss. Not dismiss.
Or reversion. How can you revert some
How can it revert?
when he is not in
From
service?
scale 3 to scale 2, lower stage. A huge amount.
So we'll
after taking my service, the logic says, well, you have taken my service entirely as scale 3 officer. Now you are saying, no, you are not entitled to get your scale. You are entitled to get scale 2 scale at the lower stage. Whether this is permissible or not. And for the other part is concerned, whether
So we'll be required to see the rules. What is the scope in the rule?
rule never suggest anything.
Then the judgments on these 2 points, delay and whether such an order can be passed.
At this stage, whether it will be open or not.
Very good.
Yes, here. Oh, Nandila Singhani.
So 34 first. So, but then if we have to hear out, everything is ready.
Everything is ready.
Then the other side.
Your lordships have given enough indulgence to me. I cannot. Your lordship's desire is a command.
Oh, date.
But actually,
we can have it on 12.
18 minutes. Let me
5,
start.
6, 5, 6, 12, 13. Oh, you want to start on 18?
18. At least, Milord, if I can, I know, Milord, it's a judicial mind. If you can reopen it within 5 minutes.
We have understood your case to some extent, whatever little we can understand.
If your lordship if your lordships allow me to place my case, I will not take much of your lordship's valuable public time. I will be very precise.
May not be possible.
I will make Milord 5 or 6 bullet points. I will give it to your lordships for you.
Either 5, 6 or 12, 13.
5, 6 of this one. January. Yes. 5.
Yes.
This on 5/1/2026 with a
advocate.
Please allow him.
But she says no problem, Milord. She is okay with that.
When 5, 6, 12, 13, all
Yes.
can't be taken up on 5. 6th or 12th, 13th?
My lord, my item 33.
6. Oh, there is one more case in between. You said it is the next case.
No, I said 35 and 36.
Not called. Oh,
Item number 33, my base. Whether Lordship will take the matter after recess or after tomorrow. On to 33.
33.
But it is the case I have ever seen a service jurisprudence. One charge sheet, I have given two major penalties. Lastly, my lord, it is dismissal from service.
2 penalties arising out of 1 charge memo.
Yes, one charge. And without proceeding the further stage, only second cause notice and dismissal. And it is, my lord, against the Coal India.
After 1 week, he wants 1 week. As played by this.
Item number 10.
Item 10, my lord, I appeal for the petitioner. Your lordship may recall this matter relates to, my lord, the challenging the virus of a rule, wherein, my lord, the female candidates have been completely outstepped for the recruitment process of inspectress in arm branch and as well as, my lord, in surgeon. My lord, to very candid, my lord, surgeon has not been under challenge. So I'm not putting any emphasis on that, my lord. What is under challenge is the, my lord, the recruitment rule. My lord, for the post of Calcutta police inspectress, inspector.
Process is still ongoing.
It's still ongoing, my lord. And my lord, I've been told, my lord, the written examination is over. The measurements have already been taken. Now, my lord, this has been the situation. Now, my lord, on last occasion, your lordship has asked us, both of us, to file a compilation of the judgments that we will be relying on and serve a copy. My lord, in my case, it has been done. I've been told. My lord, copies has been served. My lord,
why no interim order was ever obtained?
My lord, initially when the matter was taken up, your lordship was prone to pass the interim order.
Now at this belated stage when everything is over, what do you?
No, my lord, what at that juncture they have in the affidavit also they have stated as because the, my lord, the matter is pending with regard to the OBC recruitment in Supreme Court. My lord, the state contention was no recruitment is going on at present. That was the reason your lordship.
No, that was after the advertisement stage.
Yes, my lord. When I came
after three stages have crossed. So why didn't you take any steps?
My lord, initially when this was matter, your lordship was prone to pass an order, my lord, sitting with my lord.
That we have understood, but thereafter 2-3 stages have passed by. You have not challenged.
No, my lord,
it can be done.
My lord, initially, thereafter, my lord, having the urgency, my lord, when these things were going on, I got leave from your lordship and moved the vacation bench. But at that juncture, my senior friend took a plea whether I can move a application under Section 19 before the tribunal and come before your lordship under 226 of the Constitution, invoking, my lord, my jurisdiction. Had that been, whether it's appeal or not, but basically it's a public interest litigation or a private interest which I can assail before the tribunal and come before your lordship. My lord, that was the reason.
It's a private issue.
Ultimately, I have to file an affidavit. My lord, the honorable vacation bench granted me leave to file my documents to show my credentials that yes, I was otherwise eligible. Had that been, that embargo would not have been there. My lord, that dragged the issue further. Now, my lord, this being the situation, my lord, I have already makes a compilation. My learned senior friend has also filed a compilation. Now, what I get from the compilation is this one judgment of, my lord, the Punjab and Haryana High Court of 1966. My lord, it deals with Deputy Superintendent of Jails. My lord, 66, sir. My lord, it's 1966 judgment. My lord, what I get, my lord, from the other side, deals with, my lord, the Superintendent of Police. My lord, wherein their lordships, my lord, after taking into cognizance of Diden Acts and, my lord, Diden judgments, my lord, has said, my lord, even one case, my lord, the prohibition under Section 30 of the Punjab Liquor Prohibition Act was also taken into consideration and said, my lord, debarbing women in certain places may be permissible. My lord, that was in 1966. My lord, now the river has flown much more, my lord, the water of Ganges has flown much, my lord. Now, my lord, after the Babita Punia's judgment, and thereafter starts with Anuj Garg in 2008, where, my lord, this very Section 30 of the Punjab Prohibition Act was taken into consideration by the Supreme Court, where it says any woman or any child, any male below 25 years are debarred from the hospitality industry in bars and places where liquors are served. Well, that was the issue.
Hospitals.
Hospitality industry.
Hospitality industry.
My lord, where the liquors were served.
There is liquor being served.
Sir, this has been this issue, my lord. My lord, initially, my lord, the writ petition was good. Writ petition was allowed.
So they were not allowed to be recruited on any post.
Any post where the liquors were served. But this was the issue there. My lord, in 2008, the Supreme Court said this bar of.
Here also, you're not allowed on any post.
I mean, allowed only one post, that is sub-inspectresses in Anam branch. But in
what is if we remember correctly, we will be considering, we will have to go through the judgments, but it talks of basically that there cannot be a total exclusion.
Absolutely, madam.
So within the cadre, there may be certain posts which you may be deprived of, but there cannot be a total inclusion. That is, if we remember correctly, that is the law laid down.
Absolutely not. But in Babita Punia, my lord, what has happened in Babita Punia and thereafter all other three judgments, my lord, initially the MOD, Ministry of Defence, in 1992, my lord, allowed 5 posts to be commissioned by female officers. my lord, again that was revised, another 5 posts was added into. So my lord, there also
women from short service
yes,
commission.
my lord, 2 permanent commission they are seeking. My lord, initially, my lord, before 1992, 5 posts were there.
So those are facts. What we are saying is,
but there is also no total exclusion. 10 posts were allowed for women officers, but permanent commission in my lord, in proper.
yes, they were not allowed at all in permanent commission.
Yes.
There was a total inclusion that they will not be given a permanent commission. PC was the issue, not
PC was-
PC on certain posts.
Yes, ma'am.
And if we remember correctly, the government notified that they are eligible for 10 services
Absolutely, your
in
lordship,
PC.
absolutely right, my lord.
So they did not allow lock, stock and barrel.
Absolutely, my lord.
So therefore, the law ultimately remains the same, that for some posts, if there is exclusion, that cannot in all cases be considered as arbitrary or being discriminatory. But a total exclusion is not permissible.
My lord, I subject lordship kindly, but it's my understanding, I may be wrong, my lord. What ultimately Bobita Puni and thereafter, my lord, Annie George judgments are there. My lord, it says, my lord, as of now, the women officers of SSC are being allowed to, my lord, be permanently commissioned in all of the posts. It's not one exclusion is there. My lord,
There
now,
is no exclusion.
my lord, now there is no exclusion. What the honorable
No,
court said?
that is the government stand.
Yes, my lord.
That is the government's stand.
Not that the order says, judgment says that there is henceforth there won't be any exclusion, but well, there are certain criteria. The criteria says, well, as because giving SSC permanent commission to an SSC officers, well, certain criteria are there. Whatever the criteria for the male officers are,
You will have to come up to those expectations. You will have to come up to that
Yeah,
expectation.
absolutely, my lord. My lord, whatever the criteria of male officers are there, that should be in absolutely parameter with the women officers. And if they fulfill that, my lord, then that cannot be, my lord, taken away. Now, my lord, the last judgment, where this, my lord, after this Bobita Punia judgment and other judgments, my lord, what the union government did, my lord, they tried to create an artificial discrimination by cutting the ACR marks or saying something in the ACRs. That lead to another judgment that is also in my compilation. But there is Lieutenant Colonel Nitisha versus Union of India. Well, their honorable court said this artificially taking away this woman candidates, that is also not permissible. It has to be done in a proper manner where both the male candidates and female candidates will be will be taken into consideration for their eligibility and appointment as permanent commission. Now, my lord, this being the factual fact, in my case also, my lord, what they have done, in case of inspectress of police, unarmed branch, I mean allowed. My lord, if your lordship takes up the total number of vacancies in the unarmed branch, my lord, the male vacancies are far higher in number than that of the female vacancies. So, my lord, if there is one inclusion, one club of inspectors or inspectresses unarmed, then my lord, I would have been got more opportunity in participating in those posts also. This is one part of the story. My argument would be, my lord. The other part is, my lord, I am completely outstated with regard to the armed branch is concerned.
No, but when see, both issues have to be seen. One is whether the restriction imposed is sustainable or not on the touchstone of Article 15, 16.
Absolutely.
This will be basically your
contention.
Your contention.
Absolutely.
The other aspect is now at this stage, when you have taken no steps for any interim order, when the selection process is on the final stage, people have been given result for 2-3 stages. Can the court exercise jurisdiction in favor of such a person? Why did you not? We have understood that at the initial stage, they made a representation that there was no recruitment going to be processed till such time some matter pending is decided. But after that, 2 stages have crossed. At least we don't know, but there must be a written and physical test.
Well, they have in the affidavit they have stated this, my lord. In the affidavit they have said as because it was pending, nothing is going on. Thereafter, my lord, just before the vacation, my lord, one advertisement published that henceforth we have completed this written examination, but the 4 stages are there. Now, my lord, we will be seeking names. My lord, we will be calling petitioners eligible candidates for the PMT test.
Person, whether any right is created in their favor, some equity is created in their favor, can be proceed like this.
But in my original application, my lord, as well as in this, my lord, this writ petition, my lord, basically I am challenging the virus of the rule and the advertisement itself. My lord, had that when they have said themselves, because of the pendency of an application before the Honorable Supreme Court with regard to OBC quota, they could have easily intimated the incumbents, my lord, your selection will be subject to whatever there before your lordships.
They could have done that, but they chose not to do it. They chose to proceed once the issue was over. It must have proceeded by way of a publication that such and such date is fixed for a written, such and such date is fixed for the next stage. Where were you?
Well, that very juncture, my lord, I got took leave from your lordship. My lord, your lordship granted me leave to move the vacation bench.
But then nothing happened.
Nothing. That's true, my lord. My lord,
Nothing happened and you did not succeed. And you accepted the order.
No, my lord, what has happened, my lord, at that point of time, my learned senior friend raised the issue of whether I do have a locus to move this application.
Yes, because you had not stated whether you are an SC or not. Now we remember, you had not stated your age. You had not stated that you are a member of the SC community, which you are claiming to be, that you are an applicant. So must have raised that objection. That apart, it was well within your means to obtain an interim order or to take steps if it was not granted by this court. You have accepted the order.
Be that as it may, subject lordship kindly, my lord, but still the recruitment which is under challenge, that can be looked into by lordship, my lord. Whether the recruitment, my lord, touches the
for an academic purpose.
My lord, whether this recruitment will...
No, therefore you tell us for an academic purpose. Can we do it?
My lord, I will be beseeching an interim order. That's true, my lord. I understand what your lordship has said, my lord. I follow for lordship, my lord, that I ought to have moved the Supreme Court or any other court to get that thing, get an interim order. My lord, I was also, my lord, relying on the state submission, my lord, that state being a model employer should not be doing something which is not there.
When you are in an adversarial position and you have been informed, there is a publication regarding the written stage. There is must have been a publication after that regarding a physical test. We don't know how many stages. You said 4.
4 stages, but I mean told.
So one MCQ.
One is over. One is over.
Preliminary, then
Huh?
first preliminary.
MCQ.
No. Yes.
Written examination, preliminary examination, thereafter PMT,
Then
PET.
if he is qualified, then go to the
No,
physical.
please, slowly. One is the MCQ preliminary, then an objective written exam.
No, thereafter, PMTs, physical measurement test, physical efficiency test.
So that must have carried on for days and weeks.
No, as of now, it's not been completed. Only the preliminary examination is completed.
Oh, that is the only stage.
Only stage.
Completed on 14 November.
Huh?
14 November.
What?
PMT.
Started.
No, completed.
Thereafter, is PET is there. Thereafter, another written examination would be there.
11
And
November
thereafter,
started,
interview.
and 14 November.
So, my lord, now, as of date, my lord, I may say, subject lordship kindly, my lord, nobody has accrued a right in a post, as because the selection is not complete. Selection is still in process.
There are 2 more stages.
2 more stages are still left. One is written examination. One is, my lord, the.
So written has not taken place.
No, my lord.
Then we can consider. Then we can consider.
So, my lord, lordship has, I've been told, my lord, 2 compilations have been filed, my lord. I do not know, my lord. These are my compilations, my lord. Yes, my lord.
And there is another one.
Another one filed by the state.
I have also filed a complaint.
So this one is filed by you.
Yeah. My lord, if your lordship takes up the judgment that they have annexed in their compilation, is of 1966, my lord, I will come to that.
Bare facts, just give us.
Yes, my lord. The fact is, my lord.
The advertisement is of which date?
My lord, it's sometime in the year 2023. Latter half, although dates are not been mentioned, is latter half of 2023.
For recruitment of?
Well, for the recruitment of post of in sub-inspector, sub-inspectresses.
Page 16 of my compilation.
This one.
Page 16 of my compilation.
Well, the sub-inspector, sub-inspectresses, unarmed branch, sub-inspector, armed branch, and surgeon in Kolkata Police 2023. Well, this is the entire recruitment post mentioned in the advertisement, my lord.
So 4th major column is your problem.
Yes, my lord. Well, first problem is, my lord.
First column is serial, second is category, third is unarmed,
Yes, my lord.
And fourth is armed branch. So your problem lies in the armed branch.
Armed branch, my lord, I do have a problem, my lord, with regard to, my lord, the sub-inspectors and inspectors in unarmed branch is concerned. Well, your lordship will find the total number of vacancies in unarmed branch for male is 212. And whereas in our cases come down to 27.
So that's not an exclusion.
Be that as me, my lord. I'm on armed branch, I'm in completely excluded. And a surgeon, my lord, as because it's
The
not
composition of the force, can you dictate the composition of
I cannot. All the Supreme Court said, my lord, it's up to the authority.
It's up to them to decide.
Yes, my lord, that's true, my lord.
On memory, we are saying.
No, your lordship is absolutely
subject to what you will show.
No, my lord, your lordship is absolutely right. That is the law.
Yes.
My lord, with regard to armed branch is concerned, I'm being completely outstepped, my lord. That cannot be done. In touchstone of 14
That's why we said your problem is basically the fourth column, which says armed branch applicable for male applicants only.
Yes, my lord. And surgeon, my lord, as because I have not challenged, my lord, I am not putting any emphasis on that. So, my lord, I am completely outstated in place of armed branch, my lord, which is not permissible according to me, subject to kind constitution in my lord, in touchstone of Article 15 and 16 of the Constitution. This cannot be done.
And you are relying on the judgments.
Yes, sir, I will be relying on those judgments, my lord.
Which is where is that decision where the apex court held that in absence of tribunal, the High Court should exercise or may exercise jurisdiction?
No, my lord, in this case, my lord, I will be, my lord, as because the tribunal is not functioning, when the matter was moved, my lord, there is only one member.
No, today there is no tribunal.
Yes, my lord.
So where is that judgment we are asking?
Exactly, I don't have now. I will try to place. If there is nothing, I cannot be remedialist.
No, there is a judgment. Therefore, we are asking.
2020. As of now, I don't have, but I will surely try to produce it. But when
because they may have raised that objection also. You have raised that objection.
Maintainability of the
obviously.
Surely they will do that.
Locus standi.
No, locus comes later. First is the jurisdiction. Then comes locus. Why locus?
Locus kindly see page 18 of the advertise of my compilation. What is the requirement? Height and weight 173 centimeters. Height, that means 5 feet 8 inches. There is no documentary evidence that she is 5 feet 8 inches height.
So does the application form require such disclosure?
Yes. Page 18. Page 18 of my compilation. Advertisement. Serial number 3.
No, what we are not asking you whether there is a prescription. We are not asking you whether there is a requirement.
Requirement.
We are asking you whether there is a requirement to disclose the height at the time of application.
If he qualifies that, then he can apply.
Are they saying that without qualifying, they should be made to a point? Normally, there is no such requirement at the time of application. That measurement is taken when physical measurement is done.
At that juncture, if I do not qualify now.
Let him raise his objection. So if you are raising such an objection, you can raise it only if there is a requirement to disclose this at the time of application, and in the application she is not eligible. Otherwise, she may be disclosed.
In the form, there is the information portion. Kindly see page 27. Clause 14. The height of a candidate may be remeasured at the stage of including a premeditation.
See, we cannot infer a requirement, and a requirement has to appear from the application form. In the application form or online application, is there a column meant for filling up the physical measurement claimed by the applicant? Is there a scrutiny based on the application?
Advertisement said,
We are not concerned with advertisement. Whether they are required to disclose this at the time of application. If they are required to disclose it at the advertisement in the application, is it your case that based on such disclosure she has already been disqualified?
no, she has not applied. She has not applied. If somebody has got qualification, wait and wait, then that will
She
be
is
just
not an applicant.
not an applicant.
Initially, this was the plea taken by my learned friend, whether I'm an applicant or if I'm an applicant, I cannot challenge. I cannot turn back and challenge the recruitment process which I am participating. But as because I'm completely outstepped, well, even I could apply. Had that been a scope of application, well,
So have you stated in the writ petition that otherwise you fulfill all the requisite qualifications?
yes, my lord, it's there. It must be there, my lord.
Vague statement. Vague statement.
Because to that extent you will have to show us that you are effective.
Petitioner sees a female candidate.
Please allow him to show. You have raised your objection. Let him show.
Supplementary. My lord, in my supplementary affidavit, which I have filed, is reading out one paragraph, my lord, if your lordship takes up.
You have filed a supplementary.
Yes, my lord, in term leave granted by the honorable division, honorable vacation bench. Well, that is last occasion, Mala, I said it's completely my fault. I will never bank on that.
Then paragraph should be deleted.
He had that day he had submitted that he is not going to press it. We have recorded in the order.
No, Mala, it's not been recorded. I will never do that, my lord.
No, but have you stated about fulfilling all the requisite qualification as per the advertisement?
Yes, my lord.
Because a person who is not qualified in terms of the advertisement, how he can?
No, my lord, there are two criteria, my lord, subject to whatever the height is not there. There are two criteria. Leaving apart Indian insolvent, those part I'm not saying, my lord. The one must be a graduate. One must be of 27 years of age in case of general category, as on 1/1/2023. And my lord, relaxation given 3 years in case of OBC and 5 years in case of SC and ST. My lord, I fulfill the age criteria as because, my lord, my date of birth is of, my lord, 1994. So I fulfill that age criteria of within 32 years, being a scheduled caste category candidate as on 1/1/2023. Now, my lord, the other criteria, my lord, which is required, my lord, that is I have to be a graduate. I'm a graduate. So, my lord, I fulfill those criteria. Now, my lord, what your lordship has just now said, my lord, in normal circumstances, if I apply, say, my lord, if there is no bar, I would have applied. Ultimately, there are measurements. The measurements also includes, my lord, chest measurements and other things. I may fail. I may not be, my lord, say whatever requirements, I may not be in the height.
But see, if eligibility is laid down in the advertisement,
yes, no.
Before you raise a grievance with respect to the advertisement, are you required to show the court that you are otherwise eligible in terms of the advertisement or not?
Absolutely, my lord. I'm bound to show, my lord.
So therefore, we are asking you if they have prescribed a minimum height criteria. If you know you don't have the minimum height criteria, can you be permitted to assail the?
My lord, only thing, my lord, this height criteria, my lord, is this, my lord, they will measure. My lord, I can give a statement whether I'm 170, my lord, it normally happens, my lord. It all depends upon the scale that, my lord, heights have been taken. My lord, I may say, my lord, in one point of time, my lord, a wooden ruler scale was used, my lord, to get a height. Now, my lord, it has been changed.
Then you would those are other line of cases that 0.2 centimeters and rounding off and all that is a different thing.
Absolutely, my lord.
But first, your claim anywhere stated that you are otherwise in terms of the advertisement eligible on all parameters which have been prescribed. And you are offended by the exclusion based on the ground of sex only.
I understand, my lord. Only thing, my lord, with regard to height part, I have not stated anything. I said I'm otherwise eligible as
Because the judgment also you are relying upon.
Yes, my lord. Yes, but I have to fulfill the criteria.
You have
That's
to
so, my lord.
fulfill.
I have to fulfill the criteria. Also, my lord, I'm nowhere. But in my contention, my lord, had that subject lordship kindly, my lord, had I had not those, my lord, prerequisites, my lord, anyone would be, my lord, I will say, who will go to assess him, my lord, if he's not, my lord, otherwise
We
eligible.
understand, but we are in a court
I mean, I have to be
where
in black and white.
where we are to decide the issue on the basis of affidavits.
Absolutely, my lord.
And when a preliminary objection is being raised,
Yes, my lord.
that an ineligible candidate should not be permitted to assail the advertisement, you will have to meet it.
My lord, I will meet it if lordship, then my lord, I will make an affidavit if required, subject lordship kindly, that yes, I am otherwise eligible, including height. My lord,
But there is no disclosure required in the online
no, my
application.
lord. There is a brochure that says these are the requirements for which
The online application form is part of the record.
yes, my lord, it's there. The application form is there, my lord. The brochure part that says somebody has to be this and that. My lord, this is the brochure part. The online application, my lord, they can only produce, my lord, is no hard copies been generated there. My lord, no hard copies generated. I have to fill it online. So, my lord, only what we get the brochure. The brochure says of, my lord,
You have filled the form. You have not filled
no,
the
my
form.
lord. I have not filled the form, as because I cannot. Had I filled it from, then my learned senior from take a plea that he has participated in the selection process, been unsuccessful, he has turned back and challenged.
Why? After filling up, you can always
Yeah.
challenge. Who is stopping?
My lord, that is the reason, my lord, as because I have not filled the form, and I my lord, say subject lordship kindly that I am being, my lord, wrongly ousted. My lord, that is the reason I have approached the court. My lord, had that been opportunity given to me, my lord, thereafter I would have no grievance before your lordship, my lord.
What are the essential eligibility?
Yes, my lord.
Specified.
Page 18. Page 18, yes.
Essential eligibility if your lordship takes the petition, page 31. Well, this is the eligibility column.
21.
31, 31, my lord. Of the writ petition. This is the main eligibility part, I may say, my lord. Lordship has got it, my lord. At the top, your lordship will find eligibility. Must be a citizen of India. Age. The applicant must not be below 20 years and not more than 27 years as on 1/1/2023. Upper age limit is relaxable by 5 years for SC/ST and by 3 years for OBC candidates of West Bengal only, and 3 years in case of transgender person. Upper age limit is also relaxable up to 35 years for departmental Kolkata candidates of Kolkata Police only having requisite qualification. The upper age limit shall further be relaxed for departmental candidates for 5 years in case of scheduled caste, scheduled tribe candidates and 3 years in case of other backward class candidates. Departmental candidates who have already appeared in the competitive examination for recruitment of sub-inspector, sub-inspectresses, unarmed branch, sub-inspector, armed branch, and surgeon in Kolkata Police conducted by PSC, WB, PRB, and formerly KPRB on 3 earlier occasions shall not be eligible to apply. Well, date of birth as recorded in Madhyamik or equivalent admit card certificate will only be accepted as valid proof of verification age. Candidates belonging to OBC A, OBC B, if shortlisted for personality test, has to produce the revalidated, renewed, fresh OBC AB certificate issued from the competent authority within 1 year preceding 1/1/2023 during verification of testimonials at the time of personality test. Therefore, the certificate issued before 1/1/2022 needs to be revalidated, renewed from the competent authority. Candidates failing to produce the revalidated, renewed OBCA, OBCB certificate shall not be treated as OBCA or B, as the case may be. However, they may be considered as UR if they get equal or higher marks than the marks obtained by the last selected candidates in under the UR category in the final combined comparative examination, as well as aggregate provided they have not taken any age of relaxation or relaxation in cut of score as OBCA or OBCB. OBCB. Certificate of OBC without mentioning the specific category OBCA, OBCB will be treated as invalid certificate. In case of candidates of OBCA, OBCB category claims relaxation, these may not be important, but C is important, educational qualification. The applicant must have passed a bachelor's degree examination in any discipline from recognized university or its equivalent. Well, I do have that degree, my lord. For a language, the applicant must be able to read, write, speak in Bengali language. However, provision will not be applicable for the persons who are permanent residents of Hill Subdivision of Darjeeling, Kalimpong districts. For the applicant of Hill Subdivision of Darjeeling and Kalimpong district, the provisions laid down in West Bengal Official Language Act 1961 will be applicable. So, Malad, this is one part. Note, the applicants must possess the above qualification on or before the public. Malad, these are the main criteria. Your Lordship may get. Malad, next page it says, I'm asking, sir. If it is found the verification of testimonials at the stage, Malad, thereafter I am eligible to apply then. Then it says, if it is found during verification of testimonials at any stage that any candidate has acquired the qualification as stated above, at any date after the publication of this advertisement, his or candidature will be summarily rejected. Request for change of category will not be entertained after scheduled date of his her personality test. The shortlisted candidates of Hill Subdivision of Darjeeling and Kalimpong districts have to produce their domicile certificate at the time of document verification during personality test. Now, my lord says female applicants are only eligible for the post of sub-inspectors of armed branch in Kolkata Police. But thereafter, the physical measurement of the candidates. Well, these, my lord, when I got to get to that stage, it's not in the online I have to submit. Once I, my lord, pass the, my lord, test, when the next stage begins, my physical measurement test and physical efficiency test, my lord, there my physical measurement will be taken into consideration whether I, my lord, can, my lord, overcome this hurdle of 160 centimeters in case of female or 176 and 60 centimeters in case of male candidates. But that stage cannot be in the application form. But from the wordings itself, it can be clear, my lord, it can be only done at the time of testimonials have been, my lord, taken into consideration or when the PMT is taken out. It cannot be practiced.
As it appears from the scheme of the advertisement, 4 deals with eligibility.
Lord?
4.
Yes, ma'am.
Clause 4 of the advertisement appears to be dealing with eligibility.
Yes, ma'am.
And F is part of clause 4.
Yes, ma'am.
So it is, that is why it says minimum physical measurement of candidates. This is the minimum prescription being given here. For example, if they say that minimum 60% in higher secondary, can a person having 59 raise a grievance?
No, my lord, subject lordship, kindly, if I participate in a selection process, I am of the opinion that I'm 160 centimeters, same, my lord, I'm saying. I come to conclusion that I'm 160 centimeters and apply.
It's no question of opinion. You are supposed to know.
Yes, my lord,
because it is something physically verifiable. It is not an opinion to be just formed by in abstract.
No, that's true, my lord. But in many cases,
for example, just thinking out loud, if there is a requirement of 167 centimeter.
Yes,
a person who knows he is 150 centimeter, will he apply in this process?
So, my lord, then, my lord, at this stage of measurement, he will be ousted.
No, will he apply?
Normally, he should
knowing that there is no relaxation of 17 centimeters. Firstly, will he apply? And if he applies, then the fate is axiomatic.
Yes, my lord. Then the fate automatically, at the time of measurement, I will be outstated.
So therefore, when you say that it is not your case that you are not fulfilling these requirements, then you can challenge any other provision saying that I am being excluded because of this arbitrary or discriminatory clause.
Yes, my lord. Not only thing, my lord.
Otherwise, if you don't say so, if you want to proceed like that, already we can proceed.
If your lordship allows me, I can file an affidavit to the extent that whether I fulfill this 160 centimeter clause, whatever is there. But in case of Gorkhas, Rajbangshis, Garwalis and scheduled tribes, 155 centimeters. There is certain, even weight is also there. It's 49 kg.
So for all these posts, this has been prescribed. Is the physical measurement anywhere distinct for female candidates?
My lord, your lordship will find the column that they have prepared. My lord, number 1 is for sub-inspector of police. That is 167. My lord, the very first column. The second column is for the females. My lord, sub-inspectresses of police, unarmed branch, you being Kolkata Police, your lordship will find the heights are different. For the male candidates, is 167. And my lord, for the Gorkhas, Rajbangshis, Garwalis, that is 160 centimeters, my lord, in case of male candidates. For the female candidates, my lord, 160 is the norm. And my lord, for the Gorkhas, Rajbangshis, Garwalis and scheduled tribes, it comes down to 155. But if I take the same analogy here, my lord, for the armed forces, it has raised to 173 for the males. And for the Garwalis, my lord, another 10 centimeters that has been brought down. My lord, in my case also, there might be some increase. Height may increase, my lord, but again, it may be brought down subject to I being a female candidate. Whereas because they have distinctly differentiated between male and a female.
So in clause 3.
Yes, my lord, your lordship will find in case of armed police, there is no such thing. In clause 2, there is a differentiation in height with regard to the male candidate and the female candidate. Now, lord, in this part, my lord, if they have included it, the subject lordship kindly, if they have included, there would have been some relaxation for the female, might have been, as because it is apparent from there. And if your lordship takes at the very last column for the transgender, my lord, there is also certain differentiation with the height and height is concerned. The lordship will find the transgender is 162 centimeters. For the female is 160. This transgender is also allowed in Kolkata police inspectresses. Kolkata.
There is a normally they relax it by 5 centimeters.
More or less 5 centimeters, 6 centimeters, they will relax. So I will be also saying, well, if this 173 is taken as a the yardstick, well, there will be some reduction for the female candidates. Well, at least what I get from here. Normally that they are doing in other cases. My lord, 7 centimeters in case of 7 centimeters in case of inspector and inspectresses. My lord, with
is there any definition in the rule regarding armed branch and unarmed branch?
The only difference is this, my lord, both are armed. But this is one thing I was talking to a client, both are armed. But the unarmed branch polices normally operates in one of the police stations. Police station, my lord, they operate there. The armed branches operate in, my lord, the battalions that they are, my lord, in. The battalions, police battalions they have, my lord. Kolkata police battalion, they have.
Oh.
The armed branches are of the battalion. And unarmed branches.
But unarmed means investigating cadre. Armed branch means
law and order, law enforcement.
Both the cases
law enforcement.
Both cases law enforcement.
Height is too much, about 5 to 8 inches.
Crowd,
control the crowd and situation, just riot or agitation. The strong man, 5 foot 8 inches there. Normally in West Bengal, we have not seen such a height.
That cannot be there.
He is standing next to you.
No, female.
And one gentleman is sitting there also.
In what? Haryana, in most of this is Haryana and Punjab.
So anyway, we'll see, because it is what you are trying to say, if we have understood correctly, is only if they had made a provision, there would arise an occasion to see whether I fulfill the requisite height or not. Since there is no provision for ladies, there is no minimum height, where's the question of seeing whether I qualify the minimum height or not?
I don't even know.
And otherwise, the qualifications which are required, I fulfill.
I do. But this is my main contention in this matter, my lord. Now, my lord, if your lordship allows me to, file an affidavit, I can file, my lord. Subject lordship kindly.
No, if you want, we are not stopping you. If you want, but since we have started, you do it today, we can proceed tomorrow.
As a lordship, please.
Or if you need some more time, then Monday we can go ahead with it. Monday we are fixed.
Well, let that be on Monday, my lord. My junior would be here, my lord. He's also my junior in this matter. The original junior, my lord, your lordship knows, my lord, because of his, my lord, he got married on 24th and 27th was his reception day, my lord. He couldn't make it today. My lord, let that be Monday, my lord. Let him also be here.
Oh yes, last day he was saying.
Yes, my lord. He was some difficulty, my lord. That is the reason your lordship fixed it today itself.
So that will give us time to go through and refresh ourselves with the judgments also. And you have also given some judgment.
Only one judgment they have cited, my lord, of Punjab and Haryana High Court.
It's not only
that is, my lord,
the structure of the Calcutta police. Not exclusion. Entire exclusion of the ladies has not been discussed.
There is no total exclusion based on any such discriminatory parameter.
Yes. Commissioner of Police, then Additional Commissioner of Police, Joint Commissioner, then Deputy Commissioner of Police, male, Deputy Commissioner of Police, woman, then Assistant Commissioner of Police, male, Assistant Commissioner of Police, woman, Inspector of Police, promotional post, Inspector of Police, female.
You should also come with that judgment. Perhaps we are not very sure. Roger Matthew judgment.
Roger Matthew of Madras Bar Association, thereafter Roger Matthew. But we challenge this 2021 Act. That was 2020 Act of Tribunals Act.
So somewhere in that judgment, if I remember correctly, there is an observation that when a tribunal is non-functional, paragraph 320 or something like that.
Then
Like,
that
I do
judgment
have the
Justice
judgment.
Gabay delivered.
Huh?
Justice Gabay delivered on 9th or 10th November. I've got a copy of the judgment.
Now, so Roger Matthew is there, my lord. Roger Matthew is, my lord, that was with regard to again the Tribunal Act. That was under challenge. Which
There
was,
are three judgments.
yes, my lord, Madras Bar Association starts, and last been also after Roger Matthew, Madras Bar Association is there.
Madras Bar
Now,
Association
that says
Madras
that
Bar
says my lord,
Association
the tribunal can be appointed by a tribunal commission constituted by the
And the qualifications and all that.
qualification and
now, my lord, we do not know whether the tribunal will function in 6 months or not. God knows, my lord. But
Huh?
there's no member. No, my lord, some silly. I've been told by my
No,
lord,
in a few judgments, Apex Court has laid down that when the tribunal is not functional,
the writ court can take up.
then the writ court may, in an appropriate case,
I will surely find it. Roger Matthew, I do have, and I have to check it out once more.
that in connection with GST also, because GST tribunal was not in existence for a long time.
Roger Matthew is in CLAT, and GST might be there, my lord. But Roger Matthew, I do have, my lord, with me.
So that proposition also you can, both of you can see, for and against, we don't know.
Sir, matter is, my lord, I have deepest respect for my senior friend, London friend, my lord. If the matter is going on, that's fine. The moment we go outside, my lord, he helps me a lot. I must be candid to that, my lord. Even in some cases, I ask for judgment, he has provided me. So, my lord, I'm never be saying, my lord, as the matter is going on, fine, that's it.
Sometimes we also get agitated. Happens in a court proceeding.
My lord, I've rarely seen you agitated, my lord. This is, my lord, neither my lord Justice Tandon is to get
all are
agitated.
a human being. All are human beings.
My lord, I've rarely seen my lord Justice getting agitated, neither your lordship getting agitated, my lord.
I will have our shortcomings. So, first thing, since you have specifically said you are not pressing these pleadings, should we set the record straight today?
My lord, I will never say, my lord, that my learned senior friend was If that is there, my lord, it's, my lord, I am here, my lord. Whether anybody has drafted, I will take my responsibility.
Is available or not on that day? Two matters are already fixed.
Then on 9th, my lord.
9th, keep it on 9th. 2 p.m.
9th. No.
Just made in a
PM at item number 14.
saying that post time of the chicken post for which is not taken up. But therefore, she has to say that she is prevented from the this may not be qualified.
Yes.
I appear for the petitioner, my lord, but I shall be only referring, my lord, two orders passed by this honorable court. One by the honorable vacation bench, another by your lordship. Lord, first, your lordship, kindly have a look to the order, my lord, dated 22nd September 2025, passed by your lordship. 22nd September 2025, before vacation. Lord, initially, Lord, the doctor petitioner before your lordship, Lord, prayed for study leave. That was not granted. Lord, he prayed for extraordinary leave. Now, Lord, in such situation, Lord, your lordship observed in paragraph 7 of your lordship's order at internal page 3, kindly see, Lord, paragraph 7. Considering the rival submissions, we are of the view that the decision is required to be taken by the authorities in terms of Rule 175 of the said rules as extracted above, including whether the course is considered to be in public interest by the authorities. Only then they may be in a position to take an appropriate decision in this regard. Now, Lord, they were Lord, given a direction to take a decision on this. Lord, during vacation, Lord, they took a decision rejecting my claim, even for extraordinary leave, that is without pay. Lord, we filed a supplementary affidavit, brought it to the notice of the Honorable Vacation Bench. Lord, on Lord, 14th October 2025, your lordship, kindly have a look to the order passed by the Honorable Vacation Bench. 14th October 2025. Lord, paragraph 3 is very relevant. Lord, the court is of considered opinion that it is as much for public interest that a doctor duly enhances his qualification in order to serve the people better. The statutory right available to the petitioner is abundantly clear and understandable, even if not separately mentioned by this court. Now, Lord, this is the Lord, findings and observation of the Honorable Coordinate Bench. Lord, thereafter, Lord, the concerned authorities were directed to file a report expressing the view. Lord, and Lord, the matter was directed to be listed before the regular bench. Now, Lord, they filed a report, Lord, again, Lord, rejecting my claim for extraordinary leave. Lord, we filed the exception as per your lordship's direction. Now, Lord, my humble submissions before your lordship, Lord, this is the exception, Lord, I am filing, copy has been served. Lord, my humble submission before your lordship, Lord, the two orders, Lord, clearly show, Lord, that this is a the 175 rule 175 was directed to be taken note of and considered my case, and Lord, the another coordinate bench, Lord, has held that Lord, this is Lord, considered opinion that it is as much for public that a doctor duly enhances. Therefore, nothing remains to be decided on the part of the concerned authority that I cannot Lord, enhance my studies. Lord, I am foregoing my salary. I am availing extraordinary leave. Lord, let them, Lord, they cannot just simply Lord, tie me off and Lord, hold me Lord, in their grip. Lord, I am foregoing my salary for enhancement of my study leave. That is my fundamental right. And Lord, rule is very specific.
Fundamental right to leave.
No, Lord, right to education. Right to education, Lord.
When it is subject to a leave,
that's correct.
Unless you have the right to leave. So where is the right?
Right to leave.
The moment you apply, you are to be given leave. Just show that. So much argument is not required.
লিভ অ্যাপ্লাই করেছিলাম যেটা লিভ অ্যাপ্লাই করেছিলাম yes my lord any kind of leave your lordship directed
No, because ultimately now we remember this.
Lord,
The issue, please see.
Lord, read petition page 81.
When the matter was argued, it was a different bench. Please give the facts first.
Yes.
Give
yes,
the facts.
Yes. Lord, first, Lord, I am just drawing your lordship's kind attention to page 81. That is my representation. That is my representation. Lord, before the Lord, Special Secretary, Medical Education Department, and the Director of Medical Education, Government of West Bengal. Now, Lord, Lord, kindly see, Lord, I so-and-so, son of so-and-so, presently working for gain in the capacity of Professor of Radiology at College of Medicine and Sagar Datta Hospital, Kamarhati, Kolkata, Government of West Bengal. Initially, I joined in the West Bengal Health Services on 27 January 2004, and in terms of notification dated so-and-so, the 19th February 2014, my service was confirmed with effect from 27 January 2007. Sir, I am attached with the Health and Family Welfare Department, Government of West Bengal, more than long 20 years. Sir, I have qualified for PDCC course. PDCC is the full form to
Postdoctoral certificate.
Postdoctoral certificate course. Postdoctoral certificate course in neuroradiology for the session 2024-2025 conducted by West Bengal University of Health Sciences as in service candidate, and accordingly I completed my documents verification and admission process on 24th March 2025. I say that I have already deposited a sum of rupees so and so only in favor of IPG, ME and R Kolkata, and my all original documents also kept in custody of IPG, ME and R Kolkata. I say that I got the offer letter dated 18 March 2025 from West Bengal University of Health Sciences, and immediately thereafter I made an application in a common prescribed format on 19th March 2025 before the Director Medical Education, Department of Health and Family Welfare, Kamarhati, but no response was coming from the end of the concerned authority. Finally, I approached before the Honorable Court of Law for getting the 1-year study leave. Sir, I say that I have applied for availing 1-year study leave facility for pursuing the PDCC course at IPG, ME and R for the session 2024-2025. But surprisingly, till date, I have been not allowed the said facility. In this aforesaid facts and circumstances, I applied before your good self to allow me 1 year and kind of leave, such as any kind of leave, such as earned leave, extraordinary leave, half pay leave, commuted leave, etc., in accordance with rules and in terms of leave granted by the Honorable High Court, Calcutta, in the solemn order dated 16th July 2025, passed in the above referred WPST for pursuing the aforesaid course at IPGE MER under any condition that may be imposed by your good office. I am also ready to furnish a bond as per rules, and I am also ready to render clinical service at IPG, ME and R, as you have already allowed study leave to one Dr. Anup Kumar Boler under West Bengal Medical Education Service cadre on 30th April 2025 with imposed same condition. Sir, I say that till date from the day of my joining, I have rendered my services with utmost satisfaction of the authorities, and as such, there is no criminal case, departmental proceeding is pending against me. Sir, I say that this is a golden opportunity in my career for pursuing the aforesaid course, and as such, I pray for availing 1 year any kind of leave, such as so and so, in accordance with rules and in terms of leave granted by the Honorable High Court, Calcutta, in the solemn order dated so and so, passed in the above referred WPST. I undertake to comply all conditions imposed upon me for pursuing the said PDCC course at so and so. Sir, I say that the classes of the course are already started from April 2025, and minimum 80% attendance is necessary as per guideline framed by West Bengal University of Health Sciences. Therefore, I request your good self to allow my prayer for sanction of any kind of leave in accordance with rules, and after considering the order dated so and so passed by the Honorable High Court, Calcutta, enabling me to pursue the course without any hindrance and oblige. This is my representation.
in terms of this representation, the authority rejected my prayer and which was brought by way of which was brought.
How long? Course is how long?
Course is for 1 year. This is extendable. My admission process is over. Now, I am not attending I am not being able to attend my classes for the reason since they have not.
So if you have not taken admission, your seat is still vacant.
Admitted, I have taken admission. Process is over. I have deposited the government fees which were required. That is done. Only thing I need to attend my classes. That is due and pending since no decision has been taken. No NOC has been granted in my favor. That is the only case. I can continue. 80% attendance would be required. That would be fulfilled unless and until I get the no objection from my employer. I cannot attend the classes. That is the whole difficulty. And I'm taking in Institute of Postgraduate Medicine. Then we order take to make no এই order ও সব দেখে লাভ নেই এই order ফুল সব 2025 and not kindly see page yeah. It has to keep high $175 to first to run the practice. This is indispensable. It can be dispensable. Or some may be dispensable, but not all. After the nature of right, you can give direction to the right jurisdiction. Then be enforced. So I am asking, is that right? That you have applied for
You have not taken admission. You have been given an offer letter.
No, I'm showing you. Admission is there. Just a minute.
That may be relevant. Therefore, we ask. That may be relevant.
Yes.
Because if it has started in March, April 25 and 80% is mandatory.
No, that is extendable, Lord. The time is extendable.
But time would be extendable only for someone who has taken the admission. For someone who has not taken the admission, can it be extended?
No. Admission is there, Lord. Lord, page 61 and 62, if your Lordship sees. Page 61, that is the challan of money deposit. And the next page is the certificate of receipt, original documents. They have taken all my documents. So, Lord, admission is there. on 24th March 2025.
Yes, admission fee 2000.
Yes. So, my lord, the only thing which is required, my lord, by my employer is to give me the no objection so that I can attend the class. And my lord, the IPG MER is directly under the control of the state government. Directly, and I would serve, clinical service would be there, my lord, on my part. Along with my study, career building, I can not impart I can render the services clinically. That is the condition, Lord. I am prepared to furnish a bond also that I shall come
So
back.
a writ can be issued to compel them to grant you leave.
Not compelling, Lord. This is statutory provision, Lord. I am exploring the.
Please see, you are before a writ court.
That's correct, Lord.
Or you are before the tribunal.
Yes.
In either case, a direction can be issued only to enforce a right, or a direction can be issued where the authority fails to perform a direction, a positive, otherwise duty cast upon him. Then a positive direction may be issued.
Right.
Therefore, again and again, we are asking you, is there any clause mandating that the moment you want a study or any leave without pay, they have to sanction? Therefore, we ask you, is leave a matter of right?
Lord, I would say, Lord, subject to your lordship.
You may say anything. What is the law?
I would say, Lord.
Yes.
If they don't exercise, or if they don't allow, or if they
No,
reject.
exercising consideration is one thing and allowing it is a different thing. Consideration may lead to allowing, consideration may lead to rejection.
Right.
If you say the only possible outcome is to allow, that means you have a right. So that right, let
Yes,
us see.
Unless, Lord, it is not allowed, Lord, then definitely it would be hit by arbitrariness. It would be hit by arbitrariness.
Anything can be arbitrary if there is a right.
The right is there.
So therefore, under which provision the obligation is cast on the authority that when an application is made for leave, they have to sanction.
Lord, kindly see Rule 175(1). Your lordship has dealt in the previous order. Rule 175.
No, we have not dealt. We have
Your lordship considered.
We have raised the issue.
Yes.
Now we are still with that issue, and we want an answer from you that yes, look, this is a judgment which says that once an application is made for leave without pay, it has to be granted. Where is that? In our little knowledge, it is otherwise. There is no statutory right to leave. These are provisions, these are rules which regulate grant of leave.
Study leave to join him. So 175. Study leave to 175.
That's the only thing you have to show.
Lord, kindly see 175. There are judgments, Lord. There are judgments.
Last day also we had asked you this. That is it a right? That is all you have to show. The rule, see, the rule in almost every service rule, it is same. The rule only says under what circumstance a leave can be taken. The rule says what will be the consequence of the leave and the process of making an application. A rule does not say that it has to be given.
Lord, may I say this, Lord? Lord, they have to be given, I don't say. But if they choose not to give, Lord, there has to be sufficient reasons.
So therefore, they have filed in a report.
Lord, report, Lord, if your lordship sees the report, Lord, report is, Lord, definitely, Lord, I would say, Lord, to just bypass the two orders passed by this honorable court.
No, there is no order. We have at least the earlier order passed by the coordinate bench, which I was a member, I have seen. Yes. There is no direction. It is for consideration.
That's correct, Lord.
There is no direction. There is no final finding on anything.
That's correct. But consideration was directed.
The second order that you are relying upon in their vacation, that to some extent,
yes, this is public.
Has held that it is a public in
our considered view.
In our considered view.
Yes.
But
now, Lord,
even if it is for every course will ultimately serve the public. But the point is, the state has a setup of X number of doctors, if all of them want to join a course to serve the public, can the healthcare system be allowed to just stand still?
No, this is a single case, my lord. Your lordship.
Oh, no.
This is a single case. Not
There is a TR rule.
No, that is different. The tier rule, not tier rule facility, I am not availing of. Tier is something different that is guided by separate rules.
So, therefore, the grant of leave for study is guided by TR rules.
Trainee reserve rules, that is from service quota. That is a different rule altogether.
Correct. That's what we are
That is a
saying.
different rule. But here,
No, what is the difference?
difference is the tier facilities are extended to them with all service
Correct.
including salary.
Correct. So therefore, if the government is of the view that out of X we can spare 4 persons may go on TR, they may better their qualification to serve the public. These 4 people will go, we will pay them everything. So you are not within that.
No. I have not
You
thought
don't,
for it.
so apart from that, can you bypass that rule or circumvent that rule by taking another leave? If the TR rule says that particular number of candidates have to be identified, then in excess of that candidate, can you go? In excess of that quantification, can a person go?
Study
and leave the hospitals as it is?
Study leave is distinguishable from trainee reserve rule.
Let us see. How do you say?
Yes. Well, kindly see what is.
Are you covered by TR rules or not?
No. The particular case is not governed by TR rules.
It can't be. Either your service is governed by TR rules or it is not. How a particular application cannot be covered? Either if that rule applies to you, you can only make an application under that rule.
But
if that rule does not apply to you, you cannot make an application.
What are the tier rules? That I am just. This is tier rules. I have not applied for tier and I am not entitled even because
I have already read.
Latest 2015. And kindly see, I have not applied for, I am not even entitled because I have cost 50. 50 hole
You are a professor or assistant professor? You are a professor or assistant professor?
Assistant professor. Assistant professor.
Professor.
Now I am professor. Now I am professor.
Professor. Professor radiology. I mean neuro radiology. আমি অলরেডি
আমার কত
আমি একবার পেয়েছি
স্টাডি লিভটা কোথায়
স্টাডি লিভ এই যেখানে আছে maximum পেতে পারি স্টাডি
Read clause 2.
Clause 2. Yes, this applies. This applies
So
to.
therefore, you are covered. Don't say you are not covered.
No,
you are covered.
But the particular case is for study leave.
So therefore, now the issue is, if you are covered by this rule, can you claim anything in excess of this rule? Or you will have to go by this rule?
This is in my respectful submission. This is in respect of trainee reserve facility. I am not availing that.
What is trainee reserve? Read in the rule.
But kindly see clause 4, second page.
Yes.
Clause IV. This I cannot avail of this because I have cost 50. I cannot avail of this.
Correct.
Therefore,
So if you cannot,
yes,
then otherwise you will do it.
no, therefore I have applied for study leave. That is permissible. Now, your lordship, kindly see what is study leave. What is study leave? Blood.
Where is definition of trainee reserve in this rule?
Trainee
In which provision?
Yes. No, no, trainee reserve in one. Yes. না না কোথায় ট্রেনিং রিজার্ভ এটা জানতে চাই না না ট্রেনিং রিজার্ভের ডেফিনিশনটা জানতে চাইছেন রিজার্ভের ডেফিনিশন clause 3, your lordship sees. First page, criteria for placement on trainee reserve. Clause 3, first page of 2015 amendment. First page, paragraph 3 টা দেখুন। Now, Lord, study leave is provided Lord, in West Bengal Service Rules Part 1. That is a different provision altogether.
That's not for doctors.
That is not for all. That is not, your lordship, she is not a medical teacher or medical officer can avail of the study leave totaling 24 months in his service career.
So and therefore, that provision that you are reading from the service rule, is that applicable to a doctor or medical teacher?
Yes. Lord, if your lordship sees page 70 of the writ petition, one of the doctors has been allowed study leave. Page 70.
Page
70.
That invoking rule 197 of the West Bengal Service Rules. This is not under trainee reserve.
He has been given everything.
Yes. And I have been.
He is not above 50.
50 plus, not above 50.
He is not a party here. We don't know.
No.
Now you have placed the TR rules.
Yes.
Have you read clause 7?
Clause 7, please. Clause 7 to the key. Yes, Lord. I'm not seeking for Lord.
You are seeking to go for study on leave without pay.
Leave without pay.
Can you reconcile your request with Rule 7?
This is completely different, Lord, because
Can you reconcile your request with Rule 7? Please read Rule 7 slowly.
but to study and trainee reserve other than approved by the state government. No officer shall be allowed to undergo studies
In any manner other than being sponsored by the state government. There is no question of going on leave without pay. You can only go it if the state government sponsors. It pays for you. It gives you the salary. Otherwise, there is a bar under the rule.
That is in respect of trainee reserve.
That is instead, this is just read what it says. Bar to study and trainee reserve. Both.
Bar to study and trainee reserve. Other than
not bar to study under the trainee reserve. Therefore, the other gentleman whose order you were showing, he has been allowed everything. Because without sponsorship of the government, he cannot go on study.
But will kindly see this line is not subject to your lordship's kind approval. No officer shall be allowed to undergo studies on trainee reserve.
All right, that we will consider. That submission we will consider.
No, not here. If your lordship sees the person, the gentleman who has been given the study leave, and I am foregoing, I am not even seeking for study.
You are not doing a big favor to the government. You are obliged to serve the healthcare.
Yes.
And if every doctor is allowed to go for betterment of his career, what will happen, sir? Just try to visualize. If this is to be done by the court on a day-to-day basis, what will happen?
But kindly
that look, I don't want money, I am going to study. Yes, you go. And we should do it in exercise of writ jurisdiction.
But your lordship, kindly consider the individual's right also. Kindly consider.
You don't.
Because this is for only 1 year, and not only single person has
1 year you may serve 1,000 patients.
Not
maybe
in IPG
at least.
Not in IPG
in a government setup.
In IPG MER, not I shall do the clinical.
So everything should be according to your requirement of study. Can you dictate these things? No, under which provision? After Rule 7, where is the scope? But if there is a bar to study and there is a bar to trainee reserve, both bar to study and trainee reserve, other than approved by the state government.
But kindly see West Bengal Service Rules. This also applies.
This is also under the proviso to 309. This is a subsequent piece of. Both are on the same pedestal. Both are under the proviso to 309 of the Constitution of India. And this is for a special circumstance.
এটা স্টাডি লিভ কি? এটা কি স্টাডি লিভে?
And this is for the special service,
এটা কি স্টাডি লিভ?
medical only.
প্যারাগ্রাফ এটা ইন্টারিম অর্ডার।
You were showing some order passed by a coordinate bench also. Where is that?
Yes. Page
Allowing him to go on leave without
Yes,
pay. Where
yes.
is that?
Yes. Well, two orders have already been annexed in the writ petition. Well, I am just giving the page number, page 89. Page 89 and page 92. এটা কি দুটোই স্টাডি লিভ কি? দুটোই কি স্টাডি লিভ? দেখে নে, দেখি।
Undertaking. Never.
Two different coordinate benches order have been annexed. Your Lordship kindly see. That is with regard to study leave, foregoing the salary. এগুলো কি মুছে দেবো? না টিআর ফিয়ার দিয়ে দিস না।
এই appendix আছে।
ও এইটাই
একই
19
হ্যাঁ এটা 126
আর একটা না আমাদের পক্ষে ইন্টারিম অর্ডার
যাই হোক
দেখানো দরকার। But even there is a proceeding pending. I don't face any like, departmental or criminal procedure.
হয়ে গেছে এবং ওকে হেড ইউনিভার্সিটিকে কনসিডার করতে হবে, কোঅপারেট করতে হবে।
But another order, I am just by coordinate bench. This is in the nature of interim order.
So two are interim orders which you have faced. Here also one of the order is an interim order.
No, page 96, your lordship sees, it is disposed of.
So one of them, that is why we are
Yes,
saying.
one of them. Copy S6.
126 মতো।
একটু থাকলে দেন আর দাদা পড়ে নি তখন।
ওটা নিন, ওটা দাও না। ওটা দিন না, স্যার, এই যে এই প্যারাগ্রাফটা দেখুন।
Kindly see paragraph 18 and 19.
Relevant. তিনজন জাজের
ওটা ক্লিয়ার ফেসিলিটি যে দেখি
চেয়েছিল, অ্যালাউ করেছিল।
Shivani.
এখানে স্টাডি কি ভালো করে দিয়েছিল ওকে স্টাডি যে থ্রো রেসপন্ডেন্স চ্যালেঞ্জ করছে কি আর পাবে কি পাবে না সেটা এখানে ব্যাক করে দিচ্ছে কনফার্ম প্যারাগ্রাফ 2 এই যে পার্সোনাল কোর্স পোস্ট গ্রাজুয়েট কোর্স
কোর্স তো করে নিয়েছি আমি।
হ্যাঁ তারপর টিআর আমি পাইনি আমি স্টাডিটা আমার কনফার্ম আমি দরকার হলে হাইকোর্ট অর্ডারটাও দিয়ে দেবো হাইকোর্ট অর্ডার সেটা
No, I could have decided to wait a bit. They are talking.
সার্ভিস এখন লেগেছে
This is again an interim order.
Yes, that is it. Now, my lord, another judgment, another order passed by the Honorable Supreme Court, my lord, by three-judge bench, my lord. My lord, that was, my lord, in respect of the specially petition filed by the Director of Health Service against the order passed by this Honorable Court in respect of order granted in favor of the doctor's petitioner for trainee reserve facilities. My lord, the Supreme Court, my lord, has held, kindly see, the Supreme Court has held.
How that will apply to you? You
No.
say you don't want trainee reserve.
No, here the Supreme Court has said that trainee reserve that was remitted to this Honorable Court. Now that the Supreme Court has said, but you pursue your studies without salary. That is I am relying.
That order may be passed by the Supreme Court.
So my lord, I am placing reliance on that.
That may be passed by this.
I am placing reliance on that. My lord.
Right there, he was claiming as a trainee reserve. You are not claiming as a trainee reserve.
No, regarding trainee reserve, my lord, Honorable Court, this Honorable Court allowed the prayer of the doctor's petition.
Correct, under trainee reserve.
Under trainee reserve.
Yes, under trainee reserve, it could have been allowed.
Yes, that was allowed. Thereafter, the government would move the SLP. The Supreme Court said that we are remitting to
And
the.
what is the time between the allowing this by this court and the order passed by the apex court? He must have gone more than halfway through his course by then.
No, I'm just giving the date, my lord. My lord, 3rd March 2016 is the order passed by this Honorable Court. The Supreme Court passed the order on April 27, 2016. Within 3 months. I mean, we have continued our higher studies without salary.
See, the primary issue which we want to determine is there is no determination till now. Why? Because this is at least the 3rd or 4th case that we are also seeing.
Why?
Doctors applying for betterment of their qualification. Why? There is no doubt ultimately it serves the public. But the trainee reserve rule is a specific rule framed for this purpose. Now, apart from trainee reserve rule, whether under the West Bengal service rules, this issue can be considered.
Well, so far, my lord, the pursuant to the direction passed by the the coordinate bench on earlier occasion in this matter during vacation. Now, my lord, I have filed a report on the last occasion.
This is all our interim orders. Why are you relying on these? Interim orders don't constitute a binding precedent. Unless an issue is decided, is it a precedent?
No, but thing
Does
is
it
this-
have any precedential value?
No, only thing, Lord.
What only thing? Everything is left to be decided.
In terms of this order, the petitioners were allowed to pursue their higher studies.
Subject to what the High Court will decide. There is no decision regarding his right. How they will constitute a precedent?
Now, my lord, in our report, the second report, my lord,
Of 25/11/25.
25th of November 2025. Now, my lord, it was mentioned therein that first of all, my lord, you want to pursue a certificate course, not the postgraduate degree course or postdoctoral course. It is a certificate course. Now, my lord, there is no provision that we have to, my lord, grant him leave for certificate course.
Where is that? Where have you said so?
Now, my lord, it is, my lord, it is his prayer.
Where have you said that there is no provision?
My lord, may I tell? Now, my lord, in the third page of the report, in the instant case, Dr. Shantanu Das, Professor, Radiology, has already been granted any reserve facility with full government sponsorship for a period of 3 years to undergo postgraduate course in radiology from 31st May 2007 to 31st May 2010 by availing the provisions contained on the West Bengal Medical Education Service and West Bengal Health Service and West Bengal Public Health Administrative Service placement of any reserve rules. Thus, he has availed 3 years of sponsorship paid leave called by the name Tenny Reserve for prosecuting MD radiology course, which is more than the maximum permissible limit of 24 months imposed under section 2 under appendix number 5 of WBSR. Thus, he is not eligible for any further study leave as he had already availed himself 3 years of training leave by dint of West Bengal Medical Education Service of those rules. Then, my lord, the next page, if you lordship kindly come to the last page. Yes. Well, the last page, if your lordship kindly have a look, well, last page, the second paragraph. In the instant matter, Dr.
Last page, please read para 3. This is precisely what we were of the opinion.
Yes. Yes.
State government has an extremely well-defined policy for prosecuting higher course of study, which is
much
more than contained in the West Bengal service rules. So they are under a stricter scrutiny under the trainee reserve rule.
My lord.
This is precisely, we were expecting that there must be how the both rules can operate in the same field. Cannot.
That was a general, it's a specific.
This is a specific for medical service.
Specified field. And my lord, the other practical difficulty you have stated, if you lordship kindly have a look.
So, as per your report, if we have understood your case is that it is covered by trainee reserve rule.
One.
He has availed more than what is available to him under trainee reserve rule. And thirdly, that there is no question of West Bengal service rule because for his service, already there is a trainee reserve rule.
And another practical difficulty.
But you have not shown that it is a certificate course which does not come under the. You have submitted, but we have not seen.
No. My lord, only one thing, the certificate course does not come that the degree course is not equivalent to degree course. No, my lord, another thing is the practical difficulty. There are 2 persons in my lord, the same post they are in Sagardatta Medical College, in the radiology department. I have stated in my report, the last page. My lord, the 2, my lord, applied, both of them applied for study leave. One has come up before this court and other, he is, my lord, waiting on the fence. Now, Now, my lord, if this person is, my lord, released on this, then other would say, yes.
That
why
is no
this is-
ground. That is no
That is no
ground.
ground. But
Either he is entitled or he is not entitled. If he is entitled, whether others get it or not, we are not concerned.
now, my lord, so far this 2015 rule is concerned, my lord, the Roman 2 in the second page, 3.2, my lord, already gone through. That officers who had acquired any postgraduate degree, irrespective of the fact, who has already availed, he is not entitled further. Then, yes, postgraduate doctoral courses. Officers who had acquired any postgraduate degree, irrespective of the fact whether such degree was acquired with or without government sponsorship, shall only be allowed to undergo postdoctoral courses.
Which one you are reading?
My lord, that is, my lord, 3A II. Just a minute, আমি কিন্তু একবারও উঠে দাঁড়াই। ও, আচ্ছা। And my lord, the clause number 7, no officer shall be allowed to undergo studies on traineeism in any manner other than being sponsored by the state government.
This is reconcilable with 3 at page 4 of your report.
Yes.
This clause 7.
My lord.
Prima facie, after reading that, we were of this opinion that it is for this special service. And West Bengal service rule is a more general provision.
General, and it is, yes, specific.
It is specific. So is there any the other judgments that he has relied upon?
And my lord, those judgments which refer to, it appears from the, my lord, so far the last judgment যেটা এক্ষুনি দিল, the Justice Boshak. My lord, the facts are totally different. For the first time, no, my lord, the earlier it appears from the, my lord, the judgment or WPST 126. No, it is not a judgment, an interim order. My lord, the petitioner participated selection process for purpose of studying MD in community medicine, and then, my lord, it further appears that paragraph 19, no? Paragraph 15, postgraduate degree course undertaking. Paragraph 19, certificate dated such and such of the block medical officer in his favor that if he is released on study leave, public service will not be hampered in that case. Whereas in our case, we say that public services will be hampered. And here also paragraph 19 in that judgment, the facts were study leave granted, petitioner did not receive any previous study leave. Totally different facts.
Yes, he has availed 3 years already.
He has already enjoyed 3 years.
It's not enjoyment.
Yes.
Not enough.
Not
I have
enough.
bond also, Lordship. For that period, I have pursued the bond period also over. I have pursued the bond for that period, and that has already been over. And Lordship, at that material point, I was in West Bengal Health Services. And Lordship, initially, page 57, kindly see, they have issued NOC to participate in this course.
So what? Therefore, in every case where NOC is issued, they have to give a leave.
No, Lordship, I am submitting.
How is that relevant?
I have, after getting permit.
Who is saying they have not given NOC? Who is saying that NOC has been fraudulently obtained or wrongly given? Grant of NOC does not guarantee a permission under trainee reserve rules.
No, sir, I am not
That is only for participating. After participating, you may not emerge successful.
What
You
is-
may emerge successful.
I should submit that. What is the purpose of NOC? I have participated, I have qualified. And Lordship, I have and Lordship, moreover,
That we have seen, that argument has been
contracted
taken
by-
note of.
Yes.
That argument has been taken note of in one of the judgments you have
Yes, Lordship.
cited.
Yes, Lordship.
Therefore, you are saying that we have understood.
And all under the same umbrella. My submission is where I have to go for IPGM.
That judgment that you are relying upon is an interim order. That's not an order. That has no value of precedence.
Next.
You have relied on 3 judgments which are interim orders.
One is also already disposed of. That is Arup Ratan Saha, page 96.
That is the only one disposed of.
And that matter was.
And in that case, just see the fact.
There was a DP, Lordship.
Huh?
There was a DP.
Just see the fact. Forget about DP. First, see the fact.
Page 92. Page 95, operative part. The read petitioner give up and is ready not to receive any financial benefit. I am also ready.
MD degree course.
Including salary undergoing this course. So whatever may be lost a degree course or certificate.
Requesting for placement as trainee reserve. Here you already obtained that. I'm not using, my lord, they enjoy.
Larger view that it is for his betterment of career.
Yes, Lordship, page 96. That matter also disposed of.
But there, my lord, the rejection was for pendency of departmental proceeding at page 95.
Lordship, condition also the same. I have to forgo the salary and others financial Lordship benefits.
Here the public interest involved.
Page 95, last paragraph, Lordship.
And page 95, lordship, in the middle, primary ground for rejection is pendency of departmental proceeding. Here the facts are totally different. That public health service, that will be prejudiced. That will be affected.
Yes.
And there is no ratio decidendi that yes, he has a right. It has to be given when once, my lord, that 3 years of benefit already given. In all the facts were different. Number one, all those cases postdoctoral or MD course. Here is a certificate course, number one. Number two, whatever the special rules is there, the trainee reserve for the purpose of the study leave, he has already, my lord, obtained. And second time, it cannot be unless it is a, my lord, that comes under that clause number 7. And it is not for public interest, we have said so. Yes, the bullet. Because, my lord,
sir.
In both the report, first report and second report, we have stated that the medical services that is being rendered from that medical college, that will be affected.
That in the last report, they have not said anything.
In the My lord, yes, in the last report, last but one paragraph, it is stated therein. In the circumstances, if permission is given to both of them, that would lead
This
to
from
service
beginning, Lordship.
difficulties and continued absence
Beginning,
of both
same
of
thing
them
has been, Lordship.
for
They
a
have-
period of 1 year would inevitably lead to hardship to the patient. It is mentioned therein.
Second.
Vice
For also third. Get.
Item 35. Item 36.
একটা তো রয়েছে টিএন চোদ্দ না আইটেম নাম্বার 14 হলো টিএন হ্যাঁ হ্যাঁ স্পেশালে দেয় তো ভালোই লাগে হুম
Is the petition about the presence of state is required? I'm not. Presence of state is required.
But it's the first time that the private respondent is appearing from single bench to this bench, my lord. Yes, my lord. Lordship will take. But we shall serve the state today and come back tomorrow. No. Private respondent. Oh, is it?
We have fixed too many cases.
Wait for minutes.
FMA all is 6 is 7. At least we can complete up to 40.
37 and 38. For the respondent in this matter, my lord. Here, my lord. The order of my lord promotion has been granted by the my lord trial court. And my lord, against that order, my lord, the Eastern Coalfield Limited preferred this appeal, my lord. Here, my lord, I sat in the departmental examination. I succeeded in the departmental examination. And there was a my lord writ petitions, my lord, filed earlier. There was a direction for my lord granting the promotion. And my lord, and to pass reason order, they passed reason order. They rejected my prayer. challenging that reason order again, I filed the writ application, and writ application was allowed in my favor. And challenging that order, my lord, they preferred this appeal. Now, thing is, my lord, very limited point involved in this appeal. They have raised one question that during my tenure in service, I developed my qualification after obtaining, my lord, the study leave from my authority.
So 37 and 38 are together, or 38
Well,
and 38?
same matter.
Same.
Matter. Only, my lord, discipline is different, but advertisement.
What is their grievance?
Their grievance is they are saying that the, my lord, certificate which I obtained through distance mode have no affiliation of AICT. But rule says, if I develop my qualification through recognized university, I am entitled to get the promotion. And I succeeded in the examination. And my lord, passed the examination. But due to that reason only, my lord, they kept withheld. Now the trial court, my lord, said that there was a direction passed in the earlier round of litigation. They did not challenge that order. And accordingly, my lord, they are, my lord, stopped to challenge that part in the instant writ application, my lord.
But they are not appearing. Last day also
They have also not appeared.
For the
And they are, my lord, I am, my lord, suffering the interim order.
led by Mr. Bannerman, praying for not today.
I am suffering interim order, my lord.
To both matters, 37
Both
and 38.
matters.
Not today.
Tomorrow, my lord. But in the daily list, my lord, this is today is only in the, it is in the appearing in the monthly list. If you also kindly direct in the daily list, my lord.
Direct?
But the matter is appearing in the monthly list or daily list. Oh, very well. Very well. Yes,
All up to 40.
$39.
And 39.
And I am for the petitioner, Lordship. I am led by Mr. Subhadev Chatterjee is leading this matter, Lordship. He is on his leg on court number 4, Lordship.
Not today. And 40.
Not today, not today.
45.
Matt 870.
In this matter, my lord, I am led by learned senior counsel Shubhir Shandal, my lord. If your lordship.
He is coming from outside.
My lord,
Last week also he has mentioned, we refuse to entertain his mentioning because he is not the appellant. I have some.
my lord, if your lordship, if your lordship kindly fixed it tomorrow At any time, my lord, I am ready with this matter.
What is the issue? Just
My lord, the issue is, my lord, regarding the non-consideration, he is for the post of company secretaryship, my lord. But if your lordship kindly allow me,
in which organization?
my lord, he is in the Coal India, my lord. Coal India, my lord, for company secretary, my lord.
He is an internal candidate or an external candidate?
The external, my lord. My lord, external candidate, my lord, the post is lordship, only the 4 post is there, my lord. 3 is for the general category and 1 for lordship for the PWD, my lord, persons with disability. And out of 3, my lord, 1 is already for the OBC, my lord, other backward classes. And now, my lord, these 2 posts, my lord, that is for the general, lordship, my learned friend is the general category, lordship, that is the admitted fact, my lord. The 2 posts has already been filled up. If your lordship kindly allow me to place the order of the learned, my lord, the order of the learned single bench, my lord. The first initiation of the writ petition, my lord.
If I remember correctly, he is perhaps alleging that someone having lower marks has been
My
appointed.
lord, that is his contention, my lord. It is not the case. Well, initially, the lordship, the requisite lordship, he has to uploaded all the documents. At the first initiation, my lord, his candidature has been rejected because of the non-supply of the.
Non-supply of what?
My lord.
Non-supply of?
Of the documents have been uploaded in the website. That is the
Which
prerequisite.
document? Which document?
Lordship, the documents means the company secretaryship, the main document.
So basic
basic criteria. In the meantime, my lord, because of the non-fulfilling the 1:3 ratio, then we took the lower portion, lower candidate who had already been uploaded the documents, but they have obtained the lower marks. In that second phase, my lord, his candidature has been considered. When we considered his candidature, then we found, my lord, that his entire documents had not been uploaded. In the meantime, my lord, we already filled up the post. Then he knocked the door of this, our High Court, my lord. Lordship, kindly allow me to place the order, my lord.
Who is leading you?
My lord, the Shubhir Sharnal, my lord, the learned senior counsel.
So today we cannot conclude. There is hardly 1 minute left.
If your lordship kindly fix tomorrow, my lord.
Tomorrow it will come. We'll take it up as the first case tomorrow.
My lord, if that be at 2 p.m., my lord. My lord, because my lord, as his junior told me, my lord, maybe in the first half, my lord.
We want to conclude this tomorrow. You please tell Mr. Sanya.
As your lordship, as your lordship.
He is appearing in person.
My lord, I am not standing on his way, my lord. I am
not, but only by prolonging, he is having to come back and forth.
It is very difficult for him.
For 2-3 weeks, he has been mentioning that he comes from Varanasi and he has come for this case only. So, in some case, make an accommodation.
My lord.
Take it up as the first case tomorrow.
As your lord.